went out in February when he was on family leave. He communicated with Mr. Gilbert's office, stating that he was on family leave and he was going to be back in May. Subsequently, Mr. Gilbert's assistant sent an email with the subpoena to the deputy around March. He missed it because that's not the proper way of service. It has to go through the general civil process server of the sheriff, and then they email the officer. I called him on the day of May 6th when he was scheduled for the deposition, and he told me that he never received a subpoena. So that's the issue with that. So it was not proper service.
So we accept that the officer may have had some confusion. We would point out that the other deputy was subpoenaed the same way, showed up and did the deposition on the scheduled time. The issue isn't any problem. The deputy isn't available, he isn't available. All we want is a date to set the depots to proceed with the case. I just don't have dates from state.
Sorry for the delay, but I just want to make sure, because this doesn't happen very often, or at least it's a relatively new addition to 3.220, which is the discovery rule. But H5, it talks about depositions of law enforcement officers, and I'm not sure who got the email, but the rule as of now says, subject to the general provisions of subdivision H1, law enforcement officers must appear for deposition without subpoena on written notice of taking deposition delivered at the physical address of a law enforcement agency or department, or the email or other address designated by law enforcement agency or department 7 days before the deposition. Now, the problem with that is, even if you serve it on the agency, they just accept them without knowing whether or not that officer might be on leave or anything else. So.
I'm so sorry, Your Honor. I need to correct the statement. No, the agency that the part of the agency that receives the subpoenas, they know whether or not the officers are on leave or it's on training or.
I understand that, but they still accept the subpoena, right?
No, they don't. If they know that, that's how it is, Your Honor.
Oh, okay.
Yes.
It
If they
must have
know that
changed
the officer
recently.
is on leave, they will respond saying that the officer is unavailable. So no, they wouldn't accept it if they know they're on leave.
Well, what actually happened in this case was the officer emailed us, said, I received your subpoena. I'm not going to be available due to family leave. I would like to reschedule it. We promptly rescheduled it, no issue. We got a date from state and we issued it. All I'm looking for is a date to reschedule this deposition. We've been trying to get it for months.
Obviously, it has to be continued for purposes of getting the deposition done, but I'm not sure. It really, I mean, he's waived his speedy trial right before, right?
Yes, Your Honor. Well, tomorrow.
But when you're asking for the continuance, is there an objection to it?
No.
Okay, I'm just not sure. There's a huge concern about it as to whose continuance it is. I mean, I'll mark it down in my paperwork that this is the situation, which I usually do, but we just got to get this thing set. Y'all have dates coming up that are available?
Yes,
that you can make
we
this
just
a
have to.
priority since they've been trying to get this deposition since February?
No, we can certainly get the time to Mr. Gilbert.
All right, anything else?
Oh, Your Honor.
No, Your
All
Honor.
right, October 29th at 9 o'clock. I think are we having the bond hearing tomorrow?
Tomorrow, I think.
Yes,
All right, and Mr. Gilbert, it's one of those things I can't, if I do one motion hearing on a pretrial conference date, then everybody's going to want their motions heard on pretrial conference date. We just
Understand,
don't
Your Honor.
have the time for it, but since it's just tomorrow, that's what I wanted to just have that date, that hearing tomorrow as well. Okay.
Thank you.
All right, thank you. You have anything else, Mr. Gilbert? All right, Mr. Switek? Okay. Mr. Stewart?
Good morning, Your Honor. May it please the court, Brad Stewart, on behalf of Donald Wayne Jesperson. Judge, for the record, this is in cases 25 CF 36, 24 CF 368, 23 CF 1009, and 1008. Your Honor, if I may pause for a moment as Mr. Jesperson signs the previously reviewed plea and sentencing agreement. Your Honor, in terms of posture on this case, Mr. Jesperson is prepared to tender a plea of no contest in case number 23 CF 1009 as charged. The other cases and counts shall be dismissed. At this point, Judge, Mr. Jesperson is entering a plea. We are going to defer the judgment and sentence for 60 days. I need to get Mr. Jesperson over to Santa Rosa County. I anticipate ridding him over there, resolving one matter, and then ridding him back here. If we could have a date certain for sentencing purposes so that we make sure we have a hold on him so that he can pop back over here. I should have that completed within the next 60 days, Judge. I do have a completed sentencing recommendation for the court, given those
So it's
circumstances.
an agreed-upon sentence.
It is agreed-upon sentence. It is not straight up to the judge. It's not straight up to the court, I mean. It is agreed-upon sentence. We just need 60 days out after entrance of this plea today. So if the
I
court...
don't understand if it's agreed upon, do you all not have Santa Rosa figured out as to what's going to happen over there? I'm trying to, you haven't given me a reason why I would do that yet.
The case in Santa Rosa County is not open. If we enter a plea today, it's sentenced to Department of Corrections. If Mr. Jesperson is then immediately transported to Department of Corrections, I have him lost and in the system, and it is really hit or miss whether or not Santa Rosa County will allow me to rid him back from the department. That's very, very difficult, as opposed to entering the plea
I
here.
think we all know it. They don't get transported to DOC tomorrow.
Within 3 weeks, Judge, if I
Okay,
can get him
well,
over to
but I
Santa
mean-
Rosa County.
But there's no open case. I'm just trying to think it out loud because there's been times, even just recently, that I've conferred with Judge Drake over there, and we've been able to transport people back and forth in order to fix these situations. I'm just trying to find out a way to do it best. Mr. Kleins, as a friend of the court, has a suggestion. As a friend of the court, do we approach? Sure.
Defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in
You can go back,
Crestview.
Miss Leone.
We have been
You can go back,
serving
Miss
the
Leone. I
area
don't think
since
there's anything secret.
1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
And in the meantime, I can reach out to Santa Rosa to see if they'll just go ahead and issue an order transporting.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family
All right, so
Vision of
Mr. Jesperson,
Crestview.
we're going to bring you
We've
back
been
tomorrow. We're going
providing
to see if we can't get this
excellent
coordinated
optical
so we can get you over to
service for
Santa
Northwest
Rosa right
Florida.
away and not have to have you come back again because frankly, it's just going to be a lot of delays because of that for you and the court. So we'll see you back tomorrow. Let's put them at 9 o'clock. And I'm going to make myself a note right now to reach out to Santa Rosa County for you.
Yes, Your Honor.
All right, thank you.
Perfect. Your Honor, that's all I have. May I be excused?
Yes, sir. Thank you, Mr. Stewart. All right, you said they're coming up right now? Okay, Mr. Riasti.
Yes, sir.
If you can bring Bradley out first.
However you want to do it.
Oops, wrong way.
So she agreed to simple battery. It's a adjudication that goes to 622. That's all it is. 622 and 150. So I could sign there. He's going to ask you one of the colloquy questions I told you right here. You have 389 days. Your Honor, if I'm, Joseph Riassi for David Bradley, who's present before the court in 2024 CF 1841. I've worked out a deal with a plea and sentencing agreement with the state for a plea to a misdemeanor charge, so there'd be no score sheet, if I might approach, Your Honor.
Yes. All right, thank you. Well, basically a time served offer.
Yes, Your Honor.
Okay. Does the state agree that he's got the 389 days to cover his 1129?
Yes, Your Honor,
Okay.
Your Honor,
All
yes.
right. And that's the state's agreement?
Yes, it is.
Okay. Raise your hand, right hand, Mr. Bradley. Do you swear or affirm testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Okay. Can you state your full name and date of birth, please?
David Bradley, date of birth is 8/14/1958.
All right. And Mr. Bradley, you're here in 24 CF 1841, where you're currently charged with aggravated battery with great bodily harm or a deadly weapon. I guess it's the latter.
Yes, Your Honor.
Okay. Which is a second-degree felony punishable up to 15 years in state prison. Do you understand that?
Yes.
All right. I've been given a plea and sentencing agreement, as your attorney announced, that the state has agreed, if you'll enter a plea to simple battery, which is a first-degree misdemeanor, punishable up to a year in county jail, that the sentence would be an adjudication of guilt, 11 months and 29 days, or that 1 day short of a year in jail, credit for 389 days that you have in, $622 in court costs, and a $150 PD fee. Is that what you want to do today?
Yes, sir.
All right. Do you have any concerns, or do you have to talk to your lawyer more about your jail credit?
No, sir.
Okay, because I don't determine the credit that jail does, but if y'all think he does, and the state agrees that he's got 389 days in, or at least enough days to cover 11 months and 29 days, and I'll certainly put that in the order. All right, Mr. Bradley, did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
And you signed it
Yes, sir.
just now here in court?
Yes, sir.
Okay. And are you satisfied with your lawyer's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
Do you understand if you enter a plea today that there won't be a trial of any kind and you're giving up your trial rights, which are on page 2 of the document you signed?
Yes, sir.
And do you understand that if you're not a U.S. citizen, that you could be deported because of this?
Yes, sir.
All right. And what is your plea to the lesser included offense of simple battery, first-degree misdemeanor?
No contest.
All right. I'll accept your no contest plea as freely, voluntarily, and knowingly given. I'm going to adjudicate you guilty of the simple battery, sentence you to 11 months, 29 days in Okaloosa County Jail with credit for the 389 days that you've already served, $622 in court costs, and a $150 PD fee. I'm going to give you a period of 90 days to either pay those costs or set up a payment plan with the clerk's office. Okay, understand?
Yes, sir.
Okay, anything else?
No, Your Honor.
All right, this is a misdemeanor, so we don't need any sentencing guidelines. I do need your fingerprints, Mr. Bradley, and then you have 30 days to appeal the judgment and sentence of the court.
Okay.
All right, thank you, sir.
Thank you.
Statute 784-031,
Yes, yes, Your Honor.
paragraph 1. 03, paragraph 1. Mr. Riasti?
Your Honor, Christian Douglas is before the court in 2023 CF 111. We were going to set this case for trial. If you remember that we had a hearing on the cell phone for the victim. It's my understanding that the state has spoken with the victim. I'll let Ms. Leone address the court.
Okay, go ahead.
Yes, Your Honor. In order to save time for everybody, I reached out to the victim, asked him if he consented to downloading his cell phone, and he did consent. So at this time, OCSO has the written consent of the victim who is working on the download.
And so, if would the state stipulate to the defense getting the download? with regard to.
No.
But once they have it, they have to give it to you, Mr.
Yeah,
Gill.
yeah, of course.
The question
I'm-
up to this point is, who's going to unlock it?
What do you
But that's
mean?
been answered now, because you
Oh,
talked to
oh.
the victim.
Yes, Your
So
Honor.
the question up until now has been that.
Yes,
But
no,
now
no.
it's resolved. So,
We're going to provide the phone download to Mr. Douglas.
okay, so what are we going to do with the case from here, Mr. Riasti?
Well, I would need another trial cycle to crunch the data. Mr. Miletick could do it quickly, but I don't think he can do it in 10 days.
Oh, I understand. Again, we've been talking about these cell phones since literally my first day in this division on December 30th. And here we are, just about 8 months later, where we've finally got to a resolution of something that was been talked about for 4 cycles now.
We could hard set it for one of the 2 weeks. I understand that one of the weeks in November is a shorter week.
It is.
If we could set it in the longer week,
How many days y'all think the trial will be? I mean, I understand there's outstanding evidence at this point.
Just probably 2 days.
excluding jury selection.
Okay.
Because my state's case may take the whole day than defense.
And I wouldn't object to a hard set for, directly to a trial week.
Just so y'all understand, and anyone else who may be trying to set a trial date in November, which is the next cycle, that first week, which is November 10th, that Monday, we could pick juries, but Tuesday is a holiday, it's Veterans Day. And then we would only have 3 more days that week. So it's just something to keep in mind if you're thinking about special setting or hard setting dates like y'all are talking about. So you'd want to put it on the second week, which would be the 17th.
Yes, Your Honor.
That would be fine, November 17th.
And that would be jury selection on Monday of that week. And
Yeah, so it would be on the 17th, and we can put it that date.
and I will clear that week of my calendar.
Short of some sort of absolute unexpected issue,
Certainly.
this is not being continued again.
No, Your Honor.
Okay. All right, so we're going to put it on 10/29 for the next pretrial, and then trial would be the second week, which is November 17th.
Yes, Your Honor.
All right, any questions about that, Mr. Douglas?
They resolved the case, Your Honor.
Me too.
That's
right.
all I have before
We'll
Your
see. We'll see you back on October 29th.
Thank you.
If there's any issues that comes out of this phone download, especially if there's going to be any motion practice out of it,
We'll bring it up.
I want it done before December 20. And when I say have it done, I mean have that hearing before December or before
Yes, sir.
October 29th, so that it's done.
Yes,
All
Your
right.
Honor.
Thank you. I just wanted. I'm not sure who.
That's
we're-
all I have before
All right.
Your Honor.
All right, Mr. Switek. There you are. Morning.
Morning, Your Honor. This is Jared Pierce before the court on several cases.
I've got them as 18 CF 2647, 24 CF 1948, 2599, and 25 CF 647. What are we doing with Mr. Pierce today?
Ms. Bosso and I have agreed to set this for docket day.
Okay, and what's going to
Hopes for
happen
a
at
plea.
docket day?
Pardon?
What's going to happen at docket day?
We hope to come to a resolution for a plea.
What if we don't come to a resolution? Is it going to be a trial, or are you going to be asking for some sort of continuance?
Um,
I believe this time it would be a continuance, but I believe we will have an answer. It's, I think, 2 new cases and a VOP, so we're trying to wrap it all up together.
Okay. Well, I understand. I just like to know what we're going to do if we get here back on Tuesday next week. And
I think
that's- y'all don't have it resolved yet. Am I setting it for trial or not? That's all I'm asking, Mr. Switek. It's not, I don't have anything sinister behind my question. All right, so plea or continue for September 2nd.
Right.
Okay.
Hard effort for plea.
Say again?
I said a hard effort for plea.
Okay.
That's on me right now.
All right. Mr. Pierce, we'll see you back on September 2nd, which is next Tuesday. Again, our docket day, which is usually Monday, is Tuesday next week because of the holiday on Monday. So we'll see you on Tuesday, September 2nd at 9 o'clock. All right. Is that all you have, Mr. Switek?
Yes, Your Honor.
Can you approach with, is it Ms., who was on your case for tomorrow? Ms. Basso? Yes, Ms. Basso, can you come on up?
34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire. Take one. Have you been injured in an accident and need righteous representation? Call us. Because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
All right, Mr. Williams, Charles Williams.
Morning, Your Honor.
Morning.
Alicia Johnson.
Good night.
Yeah.
Okay, good.
No, I know, really.
But it's not on there. Oh, she's not in jail. She actually made her bond.
Oh, she did.
All right, morning, Mr. Williams.
Good morning, Your Honor. First, I have State of Florida versus Jack Barr. That's 22. And, Your Honor, you know, last time we were here, we had a competency eval scheduled. It got done, and I've had a chance to review it. I've had no objection to the court considering it at today's hearing. The client was found competent to proceed. I'm not going to request, you know, a second opinion or anything like that. Otherwise, Your Honor, I have depositions scheduled. Oh, no. I'm waiting to get back, to hear back on some deposition dates from Ms. Glisson, who I believe is.
No, me,
Are you
Leona,
doing it?
yes.
Oh, okay.
It's my case.
It got changed. It's been, all right.
You have all of his cases, Ms. Leone?
All district, yes, Your Honor.
So, well then, I apologize. My office was trying to get dates from the wrong attorney, so that
may be
explains
the problem,
something.
then,
That could be the problem, yeah.
Has that evaluation been filed?
I think
I had it e-served. I didn't check the,
me too, Your Honor. I got an e-service on the report, so I'm not sure.
The lowest case number? Y'all are stipulating to the court making decisions solely on the one evaluation?
I stipulate to that.
Yes, Your Honor,
Judge.
stay stipulate.
I've reviewed the competency evaluation that was filed, I think just on the 19th, so about a week ago, by Dr. Zeman, finding, or opining at least, that Mr. Barr is competent to proceed based on the stipulation to have that decision made solely on the one evaluation. I'll find that he is competent to proceed. All right. You're relatively new to this case, aren't you, Mr. Williams, or no?
I'm
Relatively new to this case?
Yes, I am, Judge.
Okay. All right, so let's get those depositions moving. I know there's a couple of different cases, and then there's obviously the most current, or the newest one is related to the previous one. So let's see if we can't get all these wrapped up somewhat soon as far as depositions go, and then we'll go there. All right, October 29th at 9 o'clock will be your next court date, Mr. Barr. And I'm sure Mr. Williams will come up to see you once he has some more information and has those depositions done.
All right, ma'am. Your Honor, Mr. Cochran's approaching. That's 24 CF 2690. We have depositions scheduled on the 30th of next month, September the 30th, and then we also have, those are for all the witnesses except for the victim, Your Honor, who's underage and and lives in Alabama. So Ms. Brickman and I are going to be coordinating to make that all happen. It may be at a different date than 9:30. September the 30th, which is the date for the others. But we'll definitely endeavor to get that done before the next time we're here.
Y'all agree that there was going to be a deposition of the alleged victim, right?
That's correct, Your Honor.
All right, was there an order?
There was an order, I believe, signed on the 15th.
Okay.
Yes.
Again, I'm looking in my system, it's not there. I don't doubt that it's, if I look in the other system, it will be there. I just wanted to make sure that had been done because that was what my notes had said. Was there any issue with the CPT video? I think we talked about that last time.
No, we resolved that, Your Honor.
You resolved that as well, okay. All right, so Mr. Cochran, you're going to come back on October 29th at 9 o'clock. Looks like most of, if not all of your depositions will be done by that point, and hopefully we'll be pushing towards a resolution, trial or plea.
If I could have just a moment, Your Honor, I have a document from my client to sign.
What is this? What is?
Your Honor, we are preparing to enter a plea, and my client has another question or two that just came up, and so I'm just asking, could we pass this
Until later
temporarily
today.
to later today to give me a little more time to answer a question he just asked me?
Of course. Can we put him in an attorney-client room? All right, they're going to put him back in the room so you can go talk to him now, Mr. Williams.
Very well. As soon as I got one more, Your Honor.
Just indicate to court security once you're back and ready to go.
Okay. Your Honor, this is Corey Valley, 23 CF 1996. And we do have depositions scheduled for the 11th of November the 5th.
I know your office had been communicating with my office about depositions as recently as yesterday, so I believe that the November date is right. So no objection to a continuance.
All right. You're brand new to this case, right, Mr. Williams?
I've had it for a little bit, Your Honor. I think this is my second time up. I believe I may have been pretty brand new at that point.
Okay. I know we were trying to figure out the indigency portion of it, whether or not he was going to get a publicly appointed lawyer.
Yes, and if you recall, I went to see him that afternoon and got word back that he did not qualify. I mean, that he was still indigent based on the 2 times the federal poverty limit.
All right. So the depositions are in November.
On the
I'd still
5th.
like to, I'd rather not continue it 2 cycles, but if you can give me an update when we come back on October 29th, just to make sure the depositions are still set. Everyone's been subpoenaed. I just want to kind of keep a tight watch on this one because it's just about 2 years old. All right. October 29th at 9 o'clock, Mr. Valley, we'll see you back on that date.
And Your Honor, that's all I have. I'm going to go back and talk to Mr. Talbot, and I'll let them know.
Just tell them when you're done. Mr. Cobb, there you go. You guys always move right before you get called, and I can't find you.
I got the memo. Judge, this is State of Florida versus Victor Robinson. I'd like to leave it on the docket day, September 2nd, for plea or continuance. There are some discovery issues that I'm trying to resolve, but I'm hoping I can get up with the state in between now and then and come up with a resolution. But there were supposedly videos of the battery that took place at the jail, and when I received the discovery download, the videos weren't included in the download, and I've written the state about it, and I'm trying to get copies of those, because if there is a video, that's...
Obviously, you need to see that.
Yes, sir, I do need to see it.
Mr. Sheets?
We have that request in already, Your Honor. We're working, and as soon as we get it, we will make sure and pass it to the defense.
Let me just make sure I understand. Were there some videos included, but not that one, or just no videos at
No
all?
videos at all.
Okay.
Hold on one second. Mr. Robinson would like to say something to you, but I want to hear what he wants to say first.
Why don't you ask your lawyer about that first, Mr. Robinson?
All right, then I've resolved the issue with Mr. Robinson. I know what I need to do.
All right.
And, but I would ask that it stay on the docket for September 2nd.
All right, so Mr. Robinson, you're going to come back next Tuesday. That's September 2nd at 9 o'clock. I'm marking it as plea or continuance.
I'll bring it to you. All right. All right. Good. I'll bring it to you today.
Mr. Cobb, who do we have?
I was just signing the pleas, Judge.
Okay.
Please, sorry about that.
This is Mr. Russell.
Judge, this is Kevin Russell, State versus Kevin Russell in 24 CF 119, 23 CF 2611, 2020 CF 915. He's going to withdraw his not guilty plea and enter a plea of no contest pursuant to the terms of a plea agreement. Can I approach?
Yes, sir.
No contest in all cases, all counts. He'll receive 16 months Department of Corrections on all the felony counts. With the misdemeanor count 2 of the first case, he'll be getting time served. But everything's going to run concurrent and court cost converted to a civil lien judgment because he's going to be in prison for a minute.
All right, so the trafficking is just going to be reduced charge of possession with intent.
I looked up it's going to be an amended charge of possession with intent. Yeah, yes, sir.
Is that the proper statute number for it?
Yes, sir. I looked that up this morning before I did the plea to make sure that was the proper one.
All right. Mr. Russell, can you raise your right hand? Do you swear or affirm that testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
All right. Mr. Cobb, can you pull the microphone over to his side? That way it's picking him up.
Yes, sir, I can.
All right. Can you state your full name and date of birth, please?
5/27/75. Kevin Russell.
Kevin Russell. All right. Mr. Russell, you're here on violations of probation in 2020 CF 915 and 23 CF 2611. Then you have the new charges, which are currently trafficking in fentanyl, which is a second-degree felony punishment by up to 15 years in state prison, as well as a domestic battery charge, which is a misdemeanor punished by up to 11 months, 29 days. Do you understand those charges?
Yes.
Okay, and I've been handed a plea and sentencing agreement that calls for you to admit your violations of probation in the two lower case numbers. And then the new case, you'd be entering a no contest plea to the amended charge of possession with intent to sell, manufacture, or deliver, which is 893.13. A. And then the domestic battery would be a lesser included of just simple battery, which is the same degree of misdemeanor. Do you understand that? All right. It calls for you to be adjudicated guilty all cases, all counts. On the felony charges, 60 months Department of Corrections, and on the misdemeanor battery charge, it'd just be time served. Do you understand that? Is that what you want to do here today?
Yes.
All right. Did you go over this plea and sentencing agreement with your attorney? Did you understand it?
Yes.
Did you sign it?
Yes.
Are you satisfied with your attorney's advice and representation in this case? All right. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No.
Has anyone promised you anything in return for your plea? And do you understand that if you enter a plea to the new case, there won't be a trial of any kind, and you're giving up your trial rights or waiving your trial rights, which are on page there it is. Sorry, it's just a little bit of a different form that I'm used to, Mr. Cobb. Your trial rights are on page 2 of 5 of that agreement that you signed. You understand you're waiving those trial rights?
Yes.
All right, and you understand by admitting to the violations of probation, there won't be an evidentiary hearing where the state would have to prove you violated your probation.
Yes.
You understand you're waiving all potential defenses that you may have in all 3 of these cases. And you understand that if you're not a U.S. citizen, this could lead to your deportation.
Yes.
All right. And what is your plea in 2024 CF 119 of the lesser included offenses of possession with intent to sell, manufacture, or deliver fentanyl, and simple battery?
Contest.
All right. And as far as your violations of probation in 23 CF 2611 and 2020 CF 915, are you admitting or denying that you violated your probation?
Admitting.
Admitting.
You're admitting. Okay. I'm going to accept your no contest plea, and your admission to your violation of probation is freely, voluntarily, knowingly given. I'm going to adjudicate you guilty on all cases, all counts. As to the felony charges, 60 months Department of Corrections with credit for time served. as the misdemeanor battery charge, which is count 2 of 24 CF 119. It's going to be a time served. Sentences to run concurrent in all cases and counts. And all costs, which are going to be, the $100 per VOP. And what is the court cost on the possession with intent?
I'll fill those amounts in next time.
Say again?
I'll fill those amounts in next time.
I mean, I can't keep track of them. $515 in court costs. Were you privately retained or?
I was appointed, Judge.
Okay, so it's $100 per case for the appointed lawyer, as well as a $50 application fee. All those costs are converted to a civil lien. Anything that I've missed? This is a guideline sentence. I'm looking at the updated guidelines with the lesser included offense. Shows that he scored 41.25 months and he's receiving 60, correct?
Yes, sir, that's correct.
All right. Anything else that I've missed now?
No, you didn't miss just one thing. There is a pending motion to suppress that was filed and hasn't been addressed, so I would ask the defense withdraws that.
Yeah, we withdraw that motion and would ask the clerk to cancel that hearing that's scheduled for tomorrow afternoon.
Motion to suppress is withdrawn. Cancel tomorrow's hearing.
Oh, yeah, what's this terminate? Yeah, time.
Revoke and terminate
Revoke
the
and terminate,
probation.
yes, sir.
Thank you. All right, Mr. Russell, I'll need your fingerprints up front, then you have 30 days to appeal the judgment and sentence of the court.
Okay. See you. Judge, this is State of Florida versus Lonnie Strahan in 2021 CF 1400. We're on the docket scheduled for a trial. I had written your judicial assistant requesting specific dates, but then I spoke to Ms. Basso this morning and found out some information that she's going to have to relate to the court about the status of our trial.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza.
Based on the discussion
Stop
at the
by
bench,
and let
this
us
trial, unfortunately, is going to have to be continued again. We'll come back on October 29th, and we'll have the other case, which is the 1403 case, and I expect one of those cases will be set for trial at that time.
For our discussion, Your Honor, we understand, and we will make sure that happens. I will be in touch with Mr. Cobb as well so that he can prepare appropriately.
Okay.
With a $400,000 bond.
Just explain to Mr. Strahan that based on this information, he's requested that I file a motion concerning his $400,000 bond. I told him I would do that for him and set it for hearing as soon as possible. And I'm going to go down to the jail.
The boy admitted to lying years ago. And
Mr. Strahan.
Go down to the jail and explain the situation thoroughly with Mr. Strahan so he'll know what's going on. And I will do whatever I have to do concerning the new information, but it is what it is.
Obviously, any motions that get filed and set for hearing, we'll have hearings, but.
Yes, sir.
the prosecuting attorney had that information years.
We're good.
Thank you, Mr. Strahan. Both cases on October 29th.
So is the bond reduced?
We'll have to file a motion.
Is that tomorrow?
I'll come down and see you and talk to you about it. Okay?
Thank you.
Judge, State of Florida versus Cordell Thomas. Although this case has been around for a minute, it's fairly new for me. I received the discovery from the state, and I've gone over, I think, 2 of the body camera videos. But the most pressing matter to me is scheduling a motion to suppress that was filed, I believe, by Ms. Flowers, that has never been set for a hearing. And I reviewed.
I think it was set for a hearing at some point. I can't remember if it was with Ms. Flowers or Mr. Klein's, but it was, I think it was set, and then Mr. Thomas, I think we had a Nelson hearing regarding the situation.
Right, but that is, my main priority today is to ask for a continuance, but also to schedule the suppression hearing for the motion to suppress for hearing.
And Your Honor, if I may, I would also be asking for a continuance based on some of the things that Mr. Cobb has said, and also on my end, we just took depositions, so I want to go over that all with Mr. Thomas. I'm not sure if Mr. Cobb is aware, but I also received an amended offer from Mr. Thomas's case, a global offer, 60 months, 60 months DOC, Your Honor. So I wanted to make Mr. Thomas aware of that, and I will be up to see him at the jail next week.
He's looking at the calendar right now.
Looks like next miscellaneous criminal docket I have would be September 25th.
That's perfect.
I'm available.
What date, Your Honor, you
The
mentioned?
25th, September 25th.
Yeah,
All right, let's put it at 2 o'clock in the afternoon.
that's fine.
2 o'clock.
Yes, sir. All right, September 25th at 2 o'clock will be the motion to suppress. If you could send in a notice of hearing on that, Mr. Cobb.
Yes, sir, I will.
And then the next pretrial would be October 29th at 9 o'clock.
Yes, sir, Judge.
Anything else?
No, sir,
No,
Your
Your
Honor.
All right, thank you.
If I may, Your Honor, the PD would just ask for the October 27th date for his pretrial conference.
But he's incarcerated.
He has another case.
I understand, but he's the 29th because he's.
Oh, I'm sorry, the
custody.
29th, yes, Your Honor.
All right, so he'll be here the Wednesday, the 29th of October at 9 o'clock.
All right, thank you.
And what was your case number, Mr. Maddox?
Let me grab it for you, Your Honor.
Just want to make sure it was clear on the record that we're covering both.
24 CF 2845.
2845?
Yes, Your Honor.
All right. All right, we'll see you back on September 25th, Mr. Cordell, or
Yes, sir.
Mr. Thomas, for your motion to suppress hearing. And just, I think, just so everyone remembers, at least maybe Mr. Cobb, you didn't know this, but they gave me the video to watch because it was set. So I've already seen the video. I'll probably have to watch it again because it's been a couple of months since I've seen it. But I'll certainly, we can either do that in court, or if, I think I gave the video back. So if y'all want to give it to the disc back to me, I can watch it beforehand if you'd like. I mean, I think it's only about 15, 20 minutes, so it's not.
Yes, Your Honor.
All right, thank you.
All right, Mr. Cordell, I'll see you, Mr. Thomas, okay? All right.
All right.
All right, so can we,
That's just the fugitive case, right?
yeah, so how do we dismiss that, dispose of it? What
I
do we
think
do?
the state does that.
Is
That's on Kiana Tate, 25 CF 618.
I couldn't find them in there. Have they've been released?
Released on 7/11.
Then, yes, Your Honor, the state will dismiss that charge.
All right. All right, anything else, Mr. Cobb?
Unless the clerk tells me anything else, I don't think. Can I approach?
Yes, sir.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be
All right.
healthy.
Hilliard. Cruz.
Good morning, Your Honor.
Good morning.
I have one on your docket today. That's 24 CF 1487, Tamika Hillard.
Find it here.
Yes, Your Honor. We have a waiver on file for her.
Okay, let me try and find it. It's not under Catalinic. I think I remember seeing that now. All right. Ms. Hilliard, go ahead.
All right, Your Honor. This case is relatively new to me. I took this over about 7 or 8 days ago. I'd asked if we could move this to the October 29th. I do believe or anticipate that this case will be resolved without trial. I just need to review discovery. I've spoken to the state, and then, if we can resolve it before, I'll bring it back earlier.
Okay, you can certainly do that. I've got some limited dates for that purpose if you can, but just communicate with the state and get a date either at my office or the clerk's office. Otherwise, it'll be October 29th at 9 o'clock for the next pretrial. We'll see you back on that date, Mr.
Thank you, Judge.
All right, thank you. Ms. Dudley.
Your Honor, this is Matthew Bachman, 21 CF 2261 and 23 CF 2528. Your Honor, we did take depositions. I think we did a couple of days of depositions. I do need to reschedule some individuals who could not appear. So I'd ask for a continuance to the next cycle. And if we can get it worked out before then, obviously we'll try to get it. But I do need to take those remaining people.
Ms. Leone.
In which case, Ms. Dudley?
The
if you can
newest
remind
case
me.
is from November of +23.
Well, we did both cases and people didn't show up in both cases.
Okay,
They were
but-
officers still
Okay,
in
then.
training. There's some information I want to talk to the state. Hopefully we can get it worked out before then. And if we do, I'll get it in, try to get it in early.
How many depositions do you think you have to do
I
still?
think there's about 5 or 6. Your Honor.
All right, I'm going to call this last continuance.
Yes, sir.
Because these are very old cases.
Yes, sir.
All right, Mr. Bachman, it'll be October 29th at 9 o'clock for your next and last pretrial conference.
All right, thank you, Your Honor.
Thank you.
Your Honor, this is Justin Diaz in 21 CF 2951 and 24 CF 1499. If I may approach, Your Honor.
Yes, sir. Or yes, ma'am. All right, Mr. Diaz, raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your full name and date of birth, please?
Justin Rafael Diaz, 12/14/74, sir.
All right, Mr. Diaz, you're here in 21 CF 2951, charged with trafficking, which is a first-degree felony punished by up to 30 years in state prison. Driver on license suspended, habitual traffic offender, third-degree felony, 5 years state prison max, and resisting without violence is a first-degree misdemeanor punished by up to a year in county jail. You also have 24 CF 1499, where you have 2 counts of trafficking, again, 30 years max, possession of a controlled substance with intent, 15 years max, and possession of a controlled substance and fleeing or attempting to elude, third-degree felonies, 5-year maximum sentence. Do you understand your current charges?
Yes, sir.
All right, I've been given a plea and sentencing agreement between you and the state that calls for you in the 21 case to plead to a lesser included of possession of a controlled substance with intent, 893-131A, and as charged as to counts 2 and 3, and then in the 24 case, it's as charged as to 2 and 5, so that's 1 count of trafficking, and the fleeing to elude, the state would be dismissing counts 1, 3, and 4, is that correct?
Yes, Your Honor.
All right, and your agreed-upon sentence would be an adjudication of guilt, 92 months in the Department of Corrections with a 3-year minimum mandatory on count 2 and 24 CF 1499. Both cases would have a $1,040 court costs. In the 24 CF 1499, due to the trafficking conviction, there'd be a $50,000 fine. All costs will go to a civil judgment. All cases would run concurrent with each other, and as well as your Walton County case. Is that your understanding?
Yes, sir.
All right, is that the state's agreement?
It is, yeah.
And this appears to be a guideline sentence because the guidelines as amended are 70.575 months, and it's 92.
Great.
Everyone agree to that? Any objections to the score sheet, Ms. Dudley?
No, Your Honor.
All right. Mr. Diaz, did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Are you satisfied with your attorney's advice and representation?
Excellent, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
All right. Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
And has anyone promised you anything in order to get you to plea?
No, sir.
Do you understand by entering a plea, there won't be a trial of any kind? You're giving up your trial rights, which are listed on page 2 of the agreement that you've already signed.
I do understand.
All right, and do you understand that if you're not a U.S. citizen, you could be deported because of this?
Yes, sir.
And you understand you're waiving all potential defenses that you may have?
Yes, sir.
All right. In case 21 CF 2951, what is your plea as to the possession with intent to sell, driving while licensed, suspended habitual traffic offender, and resisting without violence?
No contest, sir.
All right, and in 24 CF 1499, trafficking of a controlled substance and fleeing or attempting to elude, what is your plea?
No contest, sir.
All right, I'm going to accept your no contest pleas as freely, voluntarily, knowingly given. State have an announcement on counts 1, 3, and 4 in 24 CF 1499.
State dismisses those counts.
State's dismissed counts 1, 3, and 4. Your sentence, Mr. Diaz, as agreed upon between you and the state, is going to be an adjudication of guilt. Let's see. I think I have to make sure this is clear. In 21 CF 2951, count 1, it'd be 92 months DOC, and then I guess 1 year county jail, 11 months, 29 days on the resisting, and 60 months on the driving while licensed, suspended habitual traffic offender. I can't give you 92 months on a 5-year cap, so I'm just making sure the paperwork is clear that you're you had a little bit of a look on your face, Mr. Diaz. So I'm just explaining.
Yes.
It's what you're expecting. I just have to give you the lesser numbers on the smaller cases,
Yes,
or the
sir,
smaller
that's fine.
counts. And then in 24 CF 1499, count 2 would be the 92 months as well. And then the fleeing or attempting to elude charge would be 60 months because that's a maximum of 5 years as well. All right. It's a 3-year minimum mandatory on count 2 of 24 CF 1499, $50,000 fine on that count, $1,040 court cost per case, and your sentence will run concurrent with each other, as well as your Walton County case 21 CF 857. Again, this is a guideline sentence. It's actually a little bit above guidelines. Anything that I've missed?
No credit for time served, yeah?
Credit for time served. Sorry, I did not say that. And all costs to a civil judgment.
Yes, sir.
All right. We'll need your fingerprints, Mr. Diaz, and then you have 30 days to appeal the judgment and sentence of the court.
Thank you, sir.
Thank you, Mr. Diaz.
Your Honor, this is Kobe Hardin, 24 CF 1881 and 24 CF 1972. Your Honor, he does have some new charges that he has picked up. He's represented by the Public Defender's Office. You know, I would ask for a continuance to the next pretrial.
No objection.
Judge, I have the new cases. First time up on
When are those from?
those case numbers, Judge.
When are they from?
Maybe last month, Your Honor, very sort of recent.
Your Honor, 1393, 1389, and 1388.
Yeah, it's 20, they're all 25, 1388, 1389, 1395.
All right. All cases will be set for October 29th at 9 o'clock.
Yes, Your Honor. Your Honor, this is Destiny Jackson at 24 CF 852 and 24 CF 1681. The state did notify me on Wednesday that they do have the cell phone downloads and needed a hard drive. I did provide a hard drive this morning. They needed 2 terabytes. I did provide. The hard drive, we did get, the court signed the order, I believe, at the end of July on the
Search warrant.
search warrant. We got the search warrant, but not the affidavit part of the search warrant. We have asked the state to provide that. As of right now, we have not received the affidavit of probable cause in this search warrant.
So they gave you the part that they would have given to the person at the house when they searched it,
Yes, sir.
but not the part that you asked for.
Yes, sir.
Do they need another order?
No, Your Honor.
Okay, it's just-
The order says it in there, it says affidavit as well. I'll make sure I do
Okay, I just
that.
wanted to make sure.
Your Honor, if we can set it for a status date, I'm trying to get these cases resolved, but I do need that information, and obviously, Mr. Jackson's sitting in jail waiting for this.
So what would you like to set it for, Ms. Dudley?
Is there a miscellaneous you have before the next pretrial, or?
There's that September 25th date.
Okay. Can we set it for that, just so I can, because if I have anything, I can get it filed as well. I just want to try to get these cases resolved.
Well, do you want to set that now or just ask for that to be set if you need it?
I want the search warrant.
Okay.
But, can we just leave it for docket day to see if they can get it to me by that day? Just something to keep it.
I understand.
Keep it moving so that there's something for law enforcement to get. We need the search warrant.
That's fine, Your Honor.
All right. So, Ms. Jackson, we're just going to keep you on docket day, which is next Tuesday, September 2nd at 9 o'clock for the status of that search warrant affidavit.
Okay, thank you.
But we fully expect the case would be potentially continued from there, unless you get your 2 terabyte hard drive filled up and see the search warrant affidavit. Maybe we can figure something out. But all right. But we'll see you next Tuesday the 2nd. So I can only give them 60 months. That's the maximum. I'd like the paperwork to be right. Make sure it's done that way. All right, sorry about that. Go
Yes,
ahead.
sir. Yeah, this
Mr.
is
Jones.
Robert Jones in 24 CF 2083 and 24 CF 2735. We have all the discovery. We are getting depositions set in his case, so I'd ask for a continuance to the next cycle.
No objection.
All right, no depots are set yet?
No, we requested dates. I believe we're just waiting to get it coordinated.
These are getting a little bit on the older side as well, but October 29th, 9 o'clock for the next pretrial. Let's make sure those depositions are resolved before then.
Yes, sir.
All right, Mr. Jones, we'll see you back October 29th.
Your Honor, this is Trace Marshall on 2019-1607-23, CF 1981. Your Honor, this is the case I got last cycle. I was retained. I got sent a link on Tuesday for discovery. I have not had a chance to download it and go through it.
All right, but I understand, Ms. Dudley, but when you got retained, he was coming to a pretrial knowing that was his last continuance when he retained you. And now you're just getting discovery 2 months later? I mean, I just need a little more initiative to be taken on these cases to get discovery. I mean, if you don't have it, you need to hound them until they give it to you, and the state needs to turn it over. I mean, this case is over 2 years old, or just at 2 years old, and it sounds like we're basically at the beginning.
I understand.
All right, I'm calling this last continuance because June was last continuance before you took it over.
Yes, sir.
And I would suggest if there's anything else that needs to be done, that you make it a priority to resolve it, because
Yes, sir.
this case doesn't need to be 2 years old. All right, last continuance, October 29th, 9 o'clock.
What was the date? 29th. Yes, Your Honor, this is Gil McGinn, 24 CF 376 and 24 CF 669. I believe we're leaving 24 CF 376 left for trial.
Yes, Your Honor, possibly the second week.
You want 669 set for trial?
376.
376, okay.
And what is that trial week?
Week of the 18th,
You said you wanted the second one?
the 15th. Yes, Your Honor, possibly. The 15th, the week of.
All right, so 24 CF 376 will be set for trial. Let's come back on September 2nd for docket day.
Yes, sir.
Trial, I'm going to mark it for the second week, which is September 15th. But obviously, we'll have to kind of hash out all those trials. I just want to see how many we're going to have and if I'm going to need any backup for those dates.
Yes, sir.
Yes, sir.
All right. And then the other case will just kind of go along with it for
Yes, sir.
status. All right. We'll see you back next week on Tuesday, Mr. McGee.
Your Honor, if I could just have 1 second, I need her to sign the plea.
Just docket day. I'm sure we'll send it for review from there, but.
Your Honor, I just need 1 second to have her sign the plea.
All right, thank you.
You know, we did go through it at the jail. I just had to update the front part of the plea form.
Just to make sure that, so this is Jennifer Odom, 24 CF 378, but she's also under Jennifer Odom caps
Yes, Your Honor.
for 24 CF 120.
Your Honor, if I may approach with the score sheet and the plea agreement.
Yes, please. All right, so this would be a downward departure,
Yes, sir.
Yes, Your Honor.
correct, Ms. Leone? And the reason for it?
Need for restitution to the victim.
Need for restitution to the victim? Do we have a number on that yet? It
We
says
do not, Your
reserved.
Honor. We are reserving for 120 days for us
To determine
to get
that.
that to us, and then we'll talk about it once we get it.
All right, Ms. Odom, can you raise your right hand? Do you swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Jennifer Nicole Odom, 11/30/1980.
And Ms. Odom, you're here in 24 CF 378, charged with possession of a firearm by a convicted felon, possession of ammunition by a convicted felon, both second-degree felonies, punished by up to 15 years in state prison, as well as possession of a controlled substance, punished by up to 5 years as a third-degree felony. You also have 24 CF 120, where you're charged with robbery without a weapon, second-degree felony, 15 years state prison maximum, tampering with a witness, second-degree in a second-degree felony, which is a first-degree felony, punished by up to 30 years in state prison, and battery, first-degree misdemeanor. You understand your current charges?
Yes, sir.
Okay. Now, I've been handed a plea and sentencing agreement between you and the state attorney that calls for you to plead to the possession of a firearm by a convicted felon in the first case, as well as the robbery and tampering charges in the second case, and the state dismissing the possession of ammunition, possession of controlled substance, and battery charges.
Yes, sir.
Is that your understanding?
Yes, it is.
All right. It's also your understanding that it'd be 3 years Department of Corrections.
Correct.
All right, and that's the minimum mandatory on the possession of the firearm.
Sir.
All right. Is that what you want to do here today?
Yes, sir.
All right. Have you gone over this plea and sentencing agreement with your lawyer?
Yes, I have.
And did you understand it?
Yes, I do.
Did you sign it?
Yes.
Are you satisfied with your lawyer's advice and representation?
Yes, sir.
And Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
You understand that if you enter a plea, there won't be a trial of any kind, and you're giving up your trial rights, which are on page 2 of the agreement you signed? Do you understand you're waiving all potential defenses that you may have to these charges? And do you understand that if you're not a U.S. citizen, that you could be deported because of this? Okay. And Ms. Odom, what is your plea to the possession of the firearm by a convicted felon, robbery without a weapon, and tampering?
No contest.
All right, I'm going to accept your no contest plea as freely, voluntarily, and knowingly given. Does the state have an announcement as to the other 3 charges?
The state dismisses those additional counts.
Okay. All right. In 24 CF 378, I'm going to adjudicate you guilty of 515 court costs, 3 years in the Department of Corrections as a minimum mandatory with credit for all time served. That will run concurrent with your other case, which is 24 CF 120, where I'm going to adjudicate you guilty 515 in court costs, 3 years Department of Corrections on count 2 with credit for time served, followed by 5 years of probation on count 1. No contact with the victim, Ms. Hinesley, anger management evaluation and any recommended treatment, substance abuse evaluation, any recommended treatment, and then the court's going to reserve on restitution for a period of 120 days. If there's not an agreement on that number, then we'll have a hearing on that.
I did explain that to her.
Okay. Anything that I've missed?
No, Your Honor.
Okay. This is a downward departure based on the state advising that the victim's need for restitution outweighs the concern for incarceration, even though Ms. Odom will be incarcerated. Ms. Odom, I'm going to need you to speak to probation first, even though you're going to go to DOC first. Before you go on probation, they'll still need to talk to you quickly. You're going to step up and get your fingerprints, and you have 30 days to appeal the judgment and sentence.
Okay, thank you.
All right, thank you. Probation first.
Yeah, this is Amon Robinson, 23 CF 812 and 24 CF 638, and 24 CF 1682. Your Honor, if we can leave him as well for docket day. He also is part of the cell phone downloads and the search warrant issue where we didn't get the affidavit.
And do we have to put that in bold next time in the order? I don't understand. That's the whole point of doing it, is to get the affidavit. All right, September 2nd at 9 o'clock, but is it going to be continued at that point once you get it? Is that just status, or are we potentially?
Just a status, Your Honor. If we can get it, then I'll be able to, if I can get a search warrant, I can look at it and I can be able to figure out what we're going to do from that point.
Okay. All right, Mr. Robinson, we'll see you next week on Tuesday, September 2nd.
Do we have Mauricia Knox? Mauricia Knox? Or Reed?
Yeah, she's under another name too, right?
Is she here?
Are you new to that case then?
Yes, sir.
Okay.
I think she has there are co-defendants as well in this.
Okay.
Yes. I think Mr. Gil Powell has one and Mr. Williams has one. If I remember correctly.
Yes.
Have you put in a notice of appearance for?
Yes, sir, I have.
The 25 CF 92, which is
Did
still,
both.
I'm
I
just
did
showing
both,
it
Your
still
Honor.
as Mr. Nope, so
Yes,
that's,
sir.
I just want to make sure that everything gets.
Yes, sir, I put in a notice for both of them. Your Honor, I would ask for a continuance where we just recently got discovery, and then I think I don't know if there's depot set, but I guess I'll have to coordinate with the other two attorneys to get that set. Once I can go through it.
When did you get on the case? I'm just asking, I'm trying to figure out why I'm not seeing things that should be there.
I believe I filed on it right at the last pretrial. Oh, let me just check real quick.
Yeah, it's got your name on it from there. Okay, I found it. You filed your notice of appearance, written plea not guilty waiver, appearance and arraignment, and demand for jury trial on June 10th, but it's still listed Mr. Nopes. So, again, I'm not asking the questions
Yes,
to
sir.
find out like what's been done wrong, other than
Yes, sir.
why
No,
isn't
no,
it showing you as the attorney of record when it's been 2.5 months?
That's happened in the South End as well. That's been a kind of thing.
Oh, I know. I'm just
Yes, sir.
pointing it out. All right. So, what do we want to do with
If we
this?
can get a ask for a continuance, Your Honor.
Okay.
And everybody else continue theirs, but because depots aren't set. I think they were set. Then there were some issues with the time frame with Mr. Powell said there was
They
issues
had to
with
be
the time frame.
rescheduled because not everyone was involved, I think.
Yes, Your Honor, but Mr. Powell has already rescheduled it, and he's trying to serve one of the victims.
Okay.
Miss
So
Morris.
is there a date
he's
already?
done it.
Is there a date already?
Yes. But I understand because there were so many differences of opinion on how much time each attorney needs. I'll
Why
agree
don't
for
we-
you to do it separately, I guess.
Who were those two cases?
It was Tiffany Streeter and Felicia Johnson.
And that's Mr. Powell and Mr.
And
Williams?
Mr. Williams.
All right. Do y'all want to talk about it together, or?
I mean, I'll if there's a date and I can be there, I'll be there. Like I said, I didn't know they were set already.
I just don't want it to be a situation where there's controversy about who gets to spend the most time talking to the witnesses.
Understood.
I'm sorry, what is the?
That's
It's
the other
not your
Mr.
case.
Other Mr. Williams, I'm sorry.
Okay.
He was raising his hand behind you, and
That was why I had the confused look on my face.
They both are, you know.
yeah, I know, I
Mr.
see him.
Powell. Yeah.
I was making eye contact with them, and they were indicating yes, but I just wanted to make sure that y'all can get these done on the same date and not continued again for purposes of, you know, lack of coordination. Do y'all know that date that they're already set, Mr. Powell, Mr. Charles Williams? September 24th, Miss Dudley, is when they're set? Okay.
They're set from 2 to 3:30 p.m. on the 24th of September.
Okay. See how easy it is to coordinate these things? I understand. People switch attorneys or they, disagree on scheduling, but I just want to make sure it gets done.
Yes, sir.
All right. Then we'll see Miss Knox back on October 29th, 9 o'clock. Do you have anything else, Ms.
I
Dudley?
think that's all I have.
Okay.
Thank you, Your Honor.
Thank you. Mr. Powell? Mr. Powell. Morning, Mr. Powell.
Hey, Judge, good morning. Felicia Johnson, 24 CF 2693 and 25 CF 324. As we stated, Judge, we got depositions on the 24th. And if we can get service on the victim, we were having trouble doing that. But
This is the one we were just talking about with Ms. Dudley.
right, yes. I'm doing my depositions, and I got the officer set also. Two separate cases, but I've got a motion to dismiss, but I wanted to do the depositions first. It's a good motion, but we want to clear it up with the depots. I'd like to continue it to get these depots done.
You said those were September 24th? Any issues from the state?
No, you're.
All right, we'll see you back on, well, let's put it on the October 27th date since she's been released now. And that will be at 9 o'clock, Mr. Powell.
27th, Judge.
October 27th, yes, sir.
Thanks, Judge. That's all I got.
All right, thank you,
Maybe we
Mr.
can
Powell.
get through with this thing pretty soon.
I hope so. I'm trying to help y'all.
Okay. Good morning, Judge.
Good morning. I heard your trial got worked out in Santa Rosa County.
It did actually Saturday, but I appreciate the court moving it to today.
Well, so just so you know, because I'm not sure you've been over, I think all of the divisions are doing it the same way now. Judge Clark and Judge Stone and myself are doing, because the dockets got so big, pretrials on Monday of the cycle are for out of custody, Wednesday for in custody, or for in custody. So that way we can, because I think my first docket in this division for pretrials had about 550 cases on it, and we were here till 8 o'clock at night, and that's just not fair to all the people who were waiting that long for their cases to be called, and staff and everything else. So
A little different than the last time I saw you in Santa Rosa.
yeah.
Trey Parnell on behalf of Gregory Austin. Judge, this is an old case, and I just got on it. We have received most of the discovery from Ms. Merrifield's office, so we're going, there's a lot of it, we're going through it, trying to decide what depositions have been done. We have a lot of transcripts, and we're trying to match those up with notices and the people that we have left. Also, Ms. I spoke this morning and have emailed a couple of times, and I'm going to meet with her in the next, I guess, after this trial cycle. We're going to try to streamline this to bring it to resolution, because I know Mr. Austin would like that as well. So there is one issue that's been brought to my attention that the court might need to get involved. I'm told that the 5th and 7th amended discovery, one is a CPT video, the other is some voluminous DCF reports, that I'm going to need a court order to receive that discovery.
Yes, just file a DCF CPT order, and those are signed as a matter of course by the judge.
It's usually not an issue of there being any disagreement. It's just, I probably signed one already, but it didn't include you.
Right.
Because you weren't on the case yet. And I just, because it has to, you have to be ordered not to disseminate it to anybody else, that kind of stuff. So just get me the order.
Yes, sir.
And I'll get it signed.
Yes, sir. And other than just trying to get arms around it, I've had a few meetings with Mr. Austin, have another short meeting scheduled with video with him tomorrow. So we're doing our best to get our arms around this and get it moving.
All right. Well, I understand you're new to it. It's a very old case. In fact, it'll be about 2.5 years old when we get to our next date.
Sure.
So certainly make it a priority if you can.
Yes, sir.
That'll be October 29th. So again, that's the Wednesday of that week at 9 o'clock will be your next pretrial. If there's anything that comes up during your discussions with Ms. Barrickman as you're going through these things, let's get anything that needs to be set for hearing done before that date.
Yes, sir.
So we're not getting to that date and saying we got to set it for something else. I'm certainly trying to be lenient with new lawyers taking over cases, but at the same time, everyone has a right to get this thing over with.
Yes, sir.
In an
Understood.
expedited fashion at this point.
Thank you for the court's patience.
All right. Thank you, Mr. Parnell. We'll see you back October 29th, 9 o'clock.
Wonderful. Good to see you, Judge. Thank you.
You too. Thank you.
Talk to you tomorrow.
Mr. Williams.
Okay.
Talbot.
Morning again, Your Honor.
Your Honor, State of Florida versus Talbot, we're here on two case numbers again this morning, 22 CF 2507 and 20 CF 2925. And Mr. Talbot today intends to withdraw his previously entered not guilty plea in the 22 CF 2507 and enter a no contest plea. And he also intends to withdraw his denial on the VOP in 20 CF 2925 and to change that denial to an admission. Okay. And I have the agreement here. And score sheet, if I could pass them up.
You have the score. That's the same, but
All right, Mr. Talbot, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your name and date of birth, please?
William Jeremiah Talbot, birthday 10/15/1986.
All right, Mr. Talbot, you're here as announced on a violation of probation in 20 CF 2925, as well as new charges in 22 CF 2507. Those new charges are resisting without violence, possession of paraphernalia, both first-degree misdemeanors punished by up to a year in county jail. And then you're currently charged with trafficking, which is a second-degree felony as well. I've been handed a plea and sentencing agreement that would call for you to admit your violation of probation and then plead to a lesser-included possession with intent to sale, or is it sale, manufacture, deliver, or possession with intent to sale, manufacture, deliver?
possession with intent.
Possession with intent, so that's 893.13, sorry, 893.131A. And then the plea as charged to the two misdemeanors. And in return for that, Mr. Talbot, you're to be sentenced to 60 months in the Department of Corrections. Is that your understanding?
Yes, sir.
Is that what you want to do today?
Yes, sir.
All right. Did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
And did you sign it?
Yes, sir.
Did you have enough time to speak with your lawyer?
Yes, sir.
Oh, here to start. The signature page got kind of pushed to the front. I couldn't find it. All right. And in fact, y'all took a break so y'all could discuss this a little bit further, right?
Yes, sir.
Okay. So are you satisfied with your attorney's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressure, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
All right. In the new case, 22 CF 2507, do you understand if you enter a plea, there won't be a trial of any kind?
Yes, sir.
And you're giving up your trial rights, which are on page 1 of that agreement that you signed?
Yes, sir.
All right. And in 20 CF 2925, the violation of probation, do you understand by admitting your violation, there won't be a hearing where the state would have to prove that you violated your
Yes,
probation?
sir.
All right. And do you understand that you're waiving all potential defenses that you may have?
Yes, sir.
And do you understand that if you're not a U.S. citizen, I know it indicated that you are, but I have to say it to everybody, do you understand if you're not a U.S. citizen that you could be deported because of this?
Yes, sir.
All right. As to the violation of probation in 20 CF 2925, are you admitting or denying that violation?
Meeting, sir.
All right. And in 22 CF 2507, what is your plea as to the lesser included count 3, possession with intent to sell, manufacture, deliver, resisting without violence, and possession of drug paraphernalia?
No contest.
All right, I'm going to accept your no contest plea and admission to your violation of probation as freely, voluntarily, knowingly given. I'm going to adjudicate you guilty on all cases, all counts. On the VOP, as well as count 3 of the new case. It'll be 60 months in the Department of Corrections for credit for all time served. On the misdemeanors, it's just time served because I can't give you 60 months for that. $100 VOP fee, $615 in costs on the 22 case, and $250 in court-appointed legal assistance fees. You want those as civil lien at this point, Mr. Williams?
Civil lien, be fine,
All right.
Your Honor.
All costs will go to a civil lien, revoke and terminate any probation that you had in 20 CF 2925. I've reviewed the score sheet, which has a guideline sentence of 48 months, so this is above that guideline based on the reduction in the charge. It was changed from 61.5 to 48, but this is a guideline sentence. Anything that I've missed?
No, Your Honor.
No, Your Honor.
Costs are actually 666, not 615. Well, it was reduced to possession with intent.
Your Honor, be correct, that's credit for all time served,
Credit
right?
for all time served. But I sometimes say this in cases where you've got two different cases. They're concurrent, but not necessarily coterminous, which means you get credit for all the time served, but whatever you have less credit for is what's going to ultimately determine your end of sentence. All right, so it is just the 515, not the, because of the reduction in charge. All right. I need your fingerprints, Mr. Talbot, and then you have 30 days to appeal the judgment and sentence. All right, good luck, sir.
That concludes my business, Your Honor.
All right. We'll see you next time, Mr. Williams. All right. Going forward, all references to Mr. Williams is to Jay Williams.
Thank you, Judge.
I think I'm probably going to find a Mr. Williams on the docket after this. So.
You probably will.
All right, Ms. Merrifield.
My client's appearance was waived, so I figured I would jump in while she was taking fingerprints.
Okay.
Brandy Merrifield on behalf of Christopher Vogel, 25 CF 364 372. It's under Flaherty. Mr. Vogel, there's a waiver on file for him. His case has been set on the 925 miscellaneous at 2. A notice of hearing has been filed that was coordinated. I didn't see it on either docket. The state is also aware of it, as are all parties involved.
Okay.
That is correct, Your Honor. I did discuss that with Ms. Merrifield, and we have no objection to that being set on the 925 docket, and the appropriate notices have been filed.
Now, you said he waived his appearance, but he's still in custody?
He is still in custody,
Okay.
Judge. I filed a waiver of appearance on both of his cases.
I understand. I just want to make sure I understood that.
Yes, sir,
properly.
Your Honor.
All right, so it's under. All right, it'll go to September 25th at 2 o'clock.
Thank you, Your Honor. Thank you, Judge. That's all I had this morning.
All right, thank you, Ms. Merrifield. All right, is this Mr. Nopes?
Judge, the state made an offer, but it's a Department of Corrections offer, and I'm not in a position today that we can accept this. I do have him set for a motion to modify his bond on September 25th. Just appointed on June 24th.
This is Dandridge, right?
And I just got discovery on the 25th.
2 days ago, the 25th? 2 days ago, the 25th? Okay.
The matter, but I do have the motion to modify his bond for September 25th.
All right. So for pretrial, we'll put it back on to October 29th at 9 a.m. Obviously, somewhat contingent on the bond hearing. If he's released, we'll change him to the 27th.
Yes, sir.
All right, bond hearing, is that in the morning or afternoon? Do you know, Mr. Nopes? All right, so Mr. Dandridge will be back for your bond hearing on September 25th and your pretrial October 29th.
Yes, sir. Thank
All
you.
right, thank you, Mr. Dandridge.
And Judge, I've got on my list, I believe that it's Larissa Dudley's case, but the Knox case, but I'm assuming y'all fixed that.
I think we took care of that. That's October 29th at 9. Showing for you, but she put her notice in over 2 months ago.
Parker, Judge, my office is attempting to get a date cleared for the depositions. He's got 6 felony cases. We just got the discovery on the 2025 case yesterday.
The other cases are all VOPs, correct? Am I wrong on that?
They're new law violations.
All of them are?
Yeah.
So his cases go back to 2023?
No, I'm going to correct that statement. There are 2 cases, 23 CF 1799 and 24 CF 1239. They are violation of probation cases.
Okay. All right, so what are you asking for, Mr. Nopes, 1029?
Can't answer your questions and deal with this at the same
Okay.
time.
October 29th? All right, October 29th at 9 o'clock, Mr. Parker. Let's get those depositions set.
Judge, I don't know why. I mean, we're just having problems getting dates, but we need to get them set.
Yeah, a lot of depots are getting set, so. All right, thank you, Mr. Parker.
This is the last case. I just got discovery the 25th of August, so I'd ask to continue this case to the 29th.
All right, State, have any issues that need to be brought up? It's the first time up, right?
Yes, sir.
October 29th at 9 o'clock for the next pretrial conference.
Yes, sir. Thank you.
Thank you. I think there's co-defendants in that case, so if you're going to set depositions, make sure we get them all coordinated together. Seems to be an issue lately.
I've got Patrick Gundy, 25 CF 1034, and he's also got a misdemeanor, 25 MM 2164. And at this time, Your Honor, Mr. Gundy is going to withdraw his previously entered plea of not guilty and enter plea of no contest to both cases. Go ahead and put the date today, 8/27. Your Honor, if I can approach.
I'm showing he's got 2 different MM numbers, but they appear to be the same charge. So it's happened a few times that sometimes people are getting assigned 2 consecutive case numbers for the same case. But I also want to make sure that it's not an issue that's going to be a problem going forward, especially if it lists him as, in custody on that case, and then suddenly there's a imaginary case that's keeping him in jail. So that's why I try to bring it up to make sure we don't have those problems. But I'm looking at, you've got on here 25 MM 2164. There's also 2165. It doesn't have a court date listed. I'm assuming that's just the same, thank you, as 2164 case, but I just want to make sure it's clear, and we'll put that in our minutes, that 2165 is the same as 2164. I'm already doing Judge Ward's docket for you here, but I want to make sure we're getting rid of both of them. All right. Mr. Gundy, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. Can you give me your full name and date of birth, please?
Patrick Tyrell Gundy, 12/16/92.
Okay, and this is as charged on all counts? Okay. All right, Mr. Gundy, you're currently here on your felony case, which is 25 CF 1034, where you have 2 counts of possession of a controlled substance felony charges. You've got a misdemeanor marijuana charge. 1, 2, 3, 4, 5 counts of drug paraphernalia, drive-while license suspended, and reckless driving. Do you understand that?
Yes, sir.
All right, and then you've got your misdemeanor case from Judge Ward's division as 25 MM 2164, where you are charged with, oh, there it is on the bottom. Drive-while license suspended and resisting without violence. Do you understand that that's what you're facing today?
Yes, sir.
Okay. I've got the plea and sentencing agreement that calls for you on the felony case to get 24 months of probation with the Department of Corrections, $615 in costs. You're to do a substance abuse evaluation and any recommended treatment. I would waive your cost of supervision. Well, you're represented by Mr. Hardy, who's privately retained, correct? So it'd be $40 a month cost of supervision. And then the 25 MM 2164, which again is the same as 2165, it'd be adjudication of guilt, $300 in court costs and time served. Is that what you want to do today?
Yes, sir.
Did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
And did you sign it?
Sir.
Are you satisfied with your lawyer's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
You understand by entering the plea, there won't be a trial of any kind in either case?
Yes, sir.
And you understand you're giving up your trial rights, which are listed on page 1 of that agreement that you signed?
Yes, sir.
And do you understand you're waiving any potential defenses you have in either case?
Sir.
And do you understand that if you're not a U.S. citizen, that you could be deported because of this?
Yes, sir.
Okay. And what is your plea as charged in 25 CF 1034 and 25 MM 2164?
No contest.
All right, I'm going to accept your no contest plea as freely voluntarily given in all 10 counts in the felony case and the 2 counts in the misdemeanor case. In that misdemeanor 25 MM 2164, adjudicates you guilty, $300 in court costs and time served. I'm going to give you 90 days to set up a payment plan or pay those costs. Just, I think, keep them separate from probation, right?
Yes.
Or is probation, okay. Probation's giving me the nod that I got that one right. All right, and then in 25 CF 1034, it's going to be 24 months of probation with the Department of Corrections, $40 cost of supervision per month, $615 court costs, substance abuse evaluation, and any recommended treatment. This is a guideline sentence. I'm showing that the total points was 37.4, which is under the presumptive guideline for prison. Anything that I've missed?
No, Your Honor, I just wanted to check on the 2165. Which system were you seeing that on?
I'm seeing that in my system, so
Okay.
who knows? Maybe it's already been resolved some other system.
May have just been, looking at both the old benchmark and the new clerk, they're both showing a State v. Zimmerman, so a completely separate case, Your Honor. So I don't know where the mix-up is, but on both clerks' websites, it's a different individual for 2165, Your Honor.
How about that?
That's why I couldn't find it.
Maybe it's one of those AI things.
Yes, Your Honor.
Your Honor, I do have one request. Mr. Gundy travels for work. Does the court have any objection with him being able to travel for work?
Hold on a second. Let me make sure probation is listening to that, because they're being distracted by Mr. Kleins. Okay. As long as y'all have it right that there's no 2165 for Mr. Gundy, I just want to make sure it's not going to be a problem for him. Because it comes up sometimes. I mean, we get random seemingly randomly generated case numbers with people's names on them, and I don't want that to be a problem for anybody. All right, probation, he's asking for, to be able to travel for work purposes. What kind of travel are we talking about? Like out of county, out of state?
Out of state, it's not always. I do millwright shutdowns.
Okay. Well, I don't have any objection to it as long as you get it pre-approved by probation.
Yes, sir.
Where you give them, where you're going to be, what dates you're going to have to be there, and they approve it before you leave.
Absolutely.
Okay. Anything else that I need to say about that? Okay. All right, perfect. Just want to make sure. All right, Mr. Gundy, you're going to talk to probation before you leave here today. Again, I don't think, if I didn't say this in the adjudication of guilt on all counts, all cases, then we'll need your fingerprints, and you have 30 days to appeal the judgment and sentence.
Thank you, Your
Yes,
Honor.
sir.
All right,
Appreciate
thank you, Mr. Gundy.
That's all I have.
Thank
Thank
you,
you.
Mr. Hardish. Have a
Appreciate
good day. Yes. Probation's concurrent. Well, except for the misdemeanors, they would be only 1 year. Okay, that's fine. All right. 1 year probation on the misdemeanors. All right. Is this Mr. Washington? Is it two?
May we approach?
Sure.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire. Take one. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa!
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
Your Honor, this is Amos Washington before the court on 21 CF 2413. We have reached an agreement in this matter, if I may approach.
Yes. You have a score sheet?
I'll provide that at sentencing, Your Honor. I do have a copy if you'd like a copy now.
Well, I just want to make sure that, I'm assuming this is not a downward departure.
It's not, Your Honor.
Okay, I just want to be able to say that. Yes, please. Let me just take a look at it, and I'll give it right back to you, Miss Wilson. Quick math. All right, Mr. Washington, can you raise your right hand to be sworn? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, can you state your full name and date of birth, please?
Amos Edward Washington, 11/26/1991.
Okay. And Mr. Washington, you're here in 21 CF 2413, where you're currently charged with count 1, second-degree murder with a firearm, which is punishable by up to life in prison, burglary of a conveyance with assault or battery, which is a life felony as well. Count 3 is shooting into an occupied vehicle, second-degree felony, punishable up to 15 years state prison. Counts 4, 5, and 6 are child abuse without causing great bodily harm, which are third-degree felonies, punishable by up to 5 years in state prison. And then count 7 is a violation of an injunction, which is a first-degree misdemeanor, punishable by up to 1 year in county jail. Do you understand your current charges? I've been handed a plea and sentencing agreement that calls for you to plead to count 1, which is a second-degree murder with a firearm. You'd be adjudicated guilty, sentenced to 40 years in the Department of Corrections as a minimum mandatory with credit for time served. Count 3, which is the shooting into an occupied vehicle, would be an adjudication of guilt, 10 years of probation consecutive to that 40-year Department of Corrections sentence in count 1. You'd have no contact with Sylvie Ann Hine Lee, no possession of a firearm. Obviously, with a felony conviction, that would be part of your status anyway. $7,500 in restitution back to the Bureau of Victim Compensation and Crimes Compensation Trust Fund. Waive any cost of supervision due to the fact that you're indigent. $515 in court costs, $100 cost of prosecution, $100 PD fee, $50 application fee. And on count 7, which is the misdemeanor violation of an injunction, it would be 1 year of probation concurrent with count 3's probation and consecutive to the 40-year prison sentence. Is that your understanding of your agreement with the state, Mr. Washington?
Correct.
All right. And it's my understanding I'll be accepting this plea today, but sentencing, even though it's agreed upon, will be next week.
Yes.
Is that my, okay. All right, did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand it? And did you sign it?
Yes, sir.
Do you need any more time to speak with your lawyer before I accept your plea?
No, sir.
Are you satisfied with the representation and advice of your lawyer?
Sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns? Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
Sir.
All right. I think the one thing that I failed to state during going through the terms is that pursuant to your pleas on counts 1, 3, and 7, in a sentence that will be handed down next week, the state's going to be null prosing or dismissing counts 2, 4, 5, and 6. Is that correct, Ms. Glisson?
That's correct, Your Honor.
All right. Do you understand that, Mr. Washington?
Yes, sir.
All right. Do you understand by entering the no contest plea that's indicated on your form that there won't be a trial of any kind?
Yes, sir.
All right, and I'm just going to go quickly through your trial rights to make sure that you understand all those. They're on page 2 of the agreement that you've signed, but I want to make sure I go through those with you. Do you understand that you're giving up your right to plead not guilty?
Yes, sir.
Do you understand that you're giving up your right to a trial by judge or jury?
Yes, sir.
Do you understand that you're giving up your right to be represented or helped at trial by a lawyer?
Yes, sir.
Do you understand that you're giving up your right to compel or make any witnesses come to trial on your behalf?
Yes, sir.
Do you understand your right to be present when witnesses testify against you?
Sir.
Do you understand your right to you're giving up your right to cross-examine witnesses who testify against you?
Yes, sir.
Do you understand that you're giving up your right to remain silent and not testify against yourself?
Yes, sir.
Do you understand that you're giving up your right to present any and all defenses that you may have?
Yes, sir.
Do you understand that you're waiving all potential defenses you have by pleading?
Yes, sir.
Do you understand that you're giving up your right to appeal all matters, including the issue of guilt or innocence?
Yes, sir.
Do you understand you're giving up your right to file motions to suppress any evidence?
Yes, sir.
Do you understand that you're giving up your right to testify on your own behalf in the trial?
Yes, sir.
And do you understand that you're giving up your right for your attorney to further investigate the case, including locating or deposing any other potential witnesses?
Yes, sir.
Is either side aware of any DNA evidence that could potentially exonerate Mr. Washington?
No, Your Honor.
All right, Mr. Washington, do you understand that by entering this plea, if you're not a U.S. citizen, that you could be deported?
Yes, sir.
All right. And what is your plea to count 1 second-degree murder with a firearm punished by up to life in prison?
No contest.
Okay. And what is your plea to count 3 shooting into an occupied vehicle, which is a second-degree felony punished by up to 15 years in state prison?
No contest.
And what is your plea to the violation of injunction, which is a first-degree misdemeanor punished by up to a year in county jail?
No contest.
All right, I'm going to accept your no contest plea in count 1, 3, and 7 as freely, voluntarily, and knowingly given. State want to make an announcement on 2, 4, 5, and 6?
Your Honor, I will make that announcement at sentencing.
At
if that's
sentencing,
okay.
okay. All right, so your sentencing, Mr. Washington, is going to be, although it's agreed upon, is going to be set for next week, Thursday, September 4th. And that's going to be at 3 o'clock.
3 p.m., yes, Your
All
Honor.
right, and your attorney's asked about having someone appear by Zoom. I'll allow that, but I don't think they're going to be speaking. Is that correct, Mr. Washington? Okay. Anything that I've missed that we have to handle today?
Nothing from the state.
Okay. I've reviewed the guidelines. They haven't been filed yet, but I saw that this was a guideline sentence. All right. Mr. Washington, we'll see you back next Thursday, September 4th, for your sentencing.
Stay up here. Who's next? (19 CF 310).
file a written waiver of his appearance. That is 19 CF 3106.
All right, sorry, I found it.
Your Honor, we are going to be requesting a continuance in this matter.
I think we've discussed that previously about future trial dates.
Yes, Your Honor.
Is that right?
Yes, Your Honor.
All right, anything else that we need to discuss as far as what needs to be done between now and a potential trial date?
No, Your Honor.
I just don't want to rehash. We talked about it all the last time, I believe. All right, so do you want to put it on October 29th? All right, October 29th at 9 o'clock for Jacob Price. Thank you.
Your Honor, I have one more that Mr. Russell's covering for. It's going to be inmate Camden Barnum, and that case number is 22 CF 3192. This is with Miss Rachel Farkas, Public Defender's Office. She filed a motion to continue. I don't see that it was granted, so Mr. Russell has agreed to step in.
It wasn't granted. I did see it yesterday. My concern with it was we haven't really talked a lot about this case recently, and I wanted to make sure I kind of knew where things were going with it because it's a very old case. I think it's pushing 3 years or 4 years.
It's 2022. It's happened in December.
Yeah, so it's almost 3 years old. All right, so I know you're just kind of filling in, Mr. Russell, but where are we at with getting this case resolved?
Your Honor, this past Friday, Ms. Farkas conducted depositions. That was the first round that she had conducted. There were a couple of deponents who were not served for one reason or the other, but we did complete several depositions on Friday. She indicated that she would like to reset the rest of the depositions in the upcoming month or so. So for that reason, she was asking for a continuance. Ms. Farkas has recently been assigned to this case, so I have no objection.
Mr. Russell, anything from your side?
No, sir, that's my understanding, what she said.
Okay. October 29th at 9 o'clock will be the next pretrial, but I just want to make sure that this case is progressing because it is kind of old. I understand what the circumstances were up until recently when Ms. Farkas took it over. But as long as the state is continuing to fulfill its obligations under Marcy's law and contacting the family, I don't have any issue with the continuance at this point, but I'd like to see hopefully a resolution in the next cycle or two.
Yes, sir.
All right, thank you all.
Thank you, Judge.
Is that your last one, Ms. Glisson?
Yes, Your Honor, may I be excused?
Of course. All right. Mr. Kleins?
So, I'm going to have you sign and date it here. Today's date is the 27th of August.
Your Honor, this is Mr. Stephen Arp. He is present today. We are going to be entering a plea of no contest in 22 CF 1833 to count 1. In exchange for that plea, count 2 will be no pros. There was a motion to declare that statute unconstitutional. I will withdraw that motion. In 24 CF 1190, Mr. Arp would be entering a no contest plea as charged. The agreed upon disposition is that in the 1190 case, that's a failure to appear, Mr. Arp will be sentenced to time served. In 22 CF 1833, count 1, he will be placed on 5 years of sex offender probation, which will require designation as a sex offender. He will be assessed $309.72 for the cost of transportation to the Okaloosa County Sheriff's Office. As a condition of probation, he will have no internet or no internet-capable devices unless or until a risk assessment is done. He has been advised to speak to probation about that. He also will have no contact with any minor besides his own. He does have a child of his own. I did review statute 948.30. It does not apply to the particular subsection that Mr. Arp is pleading to. So he's agreeing to the sex offender probation terms, but the state is agreeing that because he's not pleading to one of the enumerated subsections in 948.30, he can have contact with his minor child. He has been previously adjudicated. He will be adjudicated on these. May I approach?
Yes. Question about probation. It's my understanding, at least looking at the paperwork, that he lived out of state at the time of this offense.
So as to that, Your Honor, at the time of the offense, Mr. Arp was a legal resident of the state of Georgia. He's originally from the state of Washington. I have told Mr. Arp, because you were a legal resident of the state of Georgia at the time, you would be entitled to a mandatory transfer to Georgia. However, his family has since moved back to Washington State, so my understanding is, and Mr. Arp is aware of this, he's most likely going to stay here in Florida while the discretionary transfer paperwork goes through for the state of Washington. So we have talked.
A little bit of time, right?
Correct, and I've advised him it could take up to 45 days. He does have he's originally from there, his family lives back there now. I don't think it would take so long, but he is aware there's a waiting process and he cannot leave the state until that takes place.
Is he aware of the conditions of his probation as well as his registration requirements that will kick in once he's released?
Your Honor, I provided him a full copy of 948.30. So.
All right, Mr. Hart, raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Can you state your full name and date of birth, please?
Stephen Richard Arp, 52873.
All right, Mr. Arp, you're here. Do you have two different cases? I'm going to show. Oh, there it is. All right, you're here in 22 CF 1833, where you're currently charged with obscene communication, which is a third-degree felony, punishable up to 5 years in state prison. You're also charged in that case with unlawful use of a two-way communication device to facilitate a felony, which is a third-degree felony, also punishable up to 5 years in state prison. You're also here on 24 CF 1190, which is a failure to appear, which is a third-degree felony as well. Do you understand your current charges?
Yes.
All right. I've been handed a plea and sentencing agreement between you and the state that calls for you to plead to count 1 as charged, which is the obscene communication. Count 2, the unlawful use of a two-way communication device, would be dismissed. And then 24 CF 1190, you would plead as charged to the failure to appear. The agreed-upon sentence between you and the state would be in 24 CF 1190, time served, court costs of $515 on failure to appear, I'm assuming. And then on 22 CF 1833, on count 1, it would be 5 years of sex offender probation. You'd be designated as a sexual offender. $615 court costs, $150 cost of defense. You have no contact with any minors besides your own legal child or children. $309.72 for cost of transportation. That's payable to Okaloosa County Sheriff's Office. You're also not to access the internet or be in possession of any internet-capable devices. Do you understand that?
I do.
Is this the state's agreement?
Yes, Your Honor, it is.
All right, it's my understanding. I'm looking at the score sheet. This would have to be a downward departure. Is that correct?
Yes, Your Honor.
Okay, and what is the reason for the downward departure?
The downward departure based on legitimate
You understand, Mr. Arp, that the only reason that you're not getting the prison sentence is because the state's agreed to give you this uncoerced plea bargain.
I do.
Right, and do you also understand, as your attorney has previously stated, that your motion to find the statute for unlawful two-way communication device use to declare it unconstitutional would be withdrawn, and that would not be considered by the court at this time?
That's correct.
Okay. Do you understand the plea and sentencing agreement that I've just read to you?
I do.
Did you go over it with your lawyer?
Yes,
And is it what you want to do today?
it is.
Did you sign the agreement?
I did.
Are you satisfied with your lawyer's advice and representation?
I am.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
None.
Are you currently suffering from any mental health issues?
No.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
They did not.
Has anyone promised you anything in return for your plea?
No.
You understand by entering the plea that there won't be a trial of any kind, and you're giving up your trial rights, which are on page 1 and continue on to page 2 of the agreement that you signed.
I agree.
And do you understand that you're waiving all potential defenses that you may have?
Yes.
And do you understand you'll be adjudicated guilty, which means it's a felony conviction and you'll be designated as a sexual offender?
I do.
All right, and do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes.
All right, and what is your plea to 22 CF 1833 count 1, which is the obscene communication?
No contest.
And what is your plea to 24 1190 failure to appear?
No contest.
All right, I'll accept your no contest pleas as freely, voluntarily, and knowingly given. State have an announcement on 22 CF 1833 count 2.
Yes, Judge, we announced a dismissal of that count.
Count 2 is dismissed. I'm going to, on 22 1833, sentence you to 5 years of sex offender probation, designate you as a sexual offender. You're to have no contact with any minors besides your own legal children. $309.72 cost of transportation. You're to have no access to the internet and do not possess or use any devices that are capable of accessing the internet. $615 in court costs, $150 cost of defense. Your attorney's indicated he's given you a copy of Florida Statute 948.30, is that correct?
Yes.
And have you been able to review that?
I have.
And so do you understand all the conditions
I do.
of your offender status?
Yes, I.
And do you understand what your attorney said about transferring your probation to another state could take some time?
Yes.
And then you're going to have to make sure you fulfill all of those offender requirements until you've transferred to Washington and then have to comply there as well.
Correct, I do.
All right, anything that I've missed?
No, Your Honor.
All right, Mr. Arp, I'm going to have you speak with probation, then I'm going to need your fingerprints, and you have 30 days to appeal the judgment and sentence of this court. Again, as far as this is a downward departure based on an uncoerced plea bargain between you and the state attorney. Thank you, Mr. Arp.
Your Honor, this is Mr. Kelvin Brown. I am in discussions with Mr. Sheik. If we could leave Mr. Brown on for plea or continue for the second. We are trying to get this resolved. I don't know if we will, but I don't want to just kick this down to October if there's any
I think
change.
my note from last time is that you were on the cusp of an agreement.
There's issues with the score sheet, but
All right, so we're going to come back on the 2nd, which is
Yes,
next
sir.
Tuesday. Okay.
see you on Tuesday.
All right, we're going to call that plea or continuance?
Yes, sir.
All right, plea or continuance on Tuesday, September 2nd, 9 o'clock.
Your Honor, this is Mr. Patrick Cannon. He's before the court on 3 cases, 25 CF 1167, 25 CF 620, and 25 CF 622. Those 620 and 22 cases are violations of probation. At this time, Mr. Cannon is executing a plea agreement to resolve these cases. In 25 CF 1167, Mr. Cannon is going to be entering a no contest plea as charged. In both 25 CF 620 and 622, he's going to be admitting the violation of supervision. The agreed-upon disposition on all cases is that Mr. Cannon will be sentenced to 9 months in the Okaloosa County Jail. That will be concurrent among all the counts and all the cases. It will be with credit for all time served. His supervision in those 620 and 622 cases will be revoked and terminated. He would be assessed a $100 cost of prosecution for each of those cases, 615 court costs in 25 CF 1167, a total of $350 for cost of defense. He has previously been adjudicated. I did explain to Mr. Cannon that his release date is going to be controlled from his most recent arrest date because this is not coterminous, but it is concurrent, so he is aware that there is going to be different end of sentence dates here. May I approach?
Yes, sir. All right, thank you. This would be a downward departure?
Yes, Your Honor, based on an uncoerced plea.
All right, Mr. Cannon, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, can you state your full name and date of birth, please?
Patrick Todd Cannon, 10/28/66.
All right, and Mr. Cannon, you're here in 25 CF 620 and 25 CF 622 for violations of probation, and in 25 CF 1167, you're here for charges of possession of a controlled substance as well as tampering with evidence. Do you understand your current charges?
Yes, Your Honor.
I've been handed a plea and sentencing agreement that calls for you to admit to the violations of your probation in the two VOP cases and plea as charged of the possession of controlled substance and, is it attempted tampering?
It is. That's what the way it's charged. The reason why I didn't put the statutory maximums is the information charges as a third-degree felony. My understanding is, number one, I've seen attempted tampering in a long time, but it should be 1 degree less. So I believe that's a first-degree misdemeanor because the tampering would have been occurring in a third-degree felony. But
I don't think I've ever heard of attempted tampering. I'm not saying it can't exist.
I reviewed the information this morning and was like, wow, I've never, there's a lot of attempts up in Crestview, apparently.
Mr. Kleins, what's the level of the felony of the tampering? Is level 3, right?
I believe it's a level 3.
So it becomes an F3L2.
Okay, it might be.
Yes, that's what
Or
it is.
reduces it a level, not a degree.
Okay, I haven't seen a lot of attempts.
I mean, it's all somewhat academic at this point because it's an agreed upon sentence. That doesn't change because of that. But,
correct.
We still like to get it right. All right. All right, Mr. Cannon, did you go over this plea and sentencing agreement with your lawyer?
Yes, Your Honor.
Did you understand it?
Yes, sir.
Did you sign the plea agreement?
Yes, Your Honor.
And are you satisfied with your attorney's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
All right, and are you currently suffering from any mental health issues? No?
No, sir.
Okay, and do you feel that you've been forced, pressured, or threatened by anyone to enter this plea?
Absolutely not.
Has anyone promised you anything in return for your plea?
No, sir.
In the violations of probation, do you understand if you admit your violation of probation, there won't be a hearing where the state would have to prove how you violated your probation?
Yes, sir.
And in the new case, the possession of controlled substance and the attempted tampering, do you understand that by entering a plea, there won't be a trial of any kind, and you give up your trial rights, which are on page 1 and page 2 of your agreement you signed?
Yes, sir.
And you understand that you're waiving all potential defenses that you may have to those cases?
Yes, sir.
All right. And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
And do you understand you'll be adjudicated guilty of each of these offenses?
Yes, sir.
All right. And what is your plea as to the 2 violations of probation? Are you admitting or denying your violation?
I'm admitting, sir.
Okay. And in 25 CF 1167, what is your plea to the possession of controlled substance and attempted tampering?
No contest, Your Honor.
All right. I'm going to accept your admissions to the violations of probation, and your no contest plea is freely, voluntarily, and knowingly given. In the 2 VOPs, it's going to be revoke and terminate your supervision. 9 months county jail, concurrent with all costs, all cases, credit for all time served. That 9 months county jail is also on the new law violation. $100 cost of prosecution times 2, $615 in court costs in the new case, and a total of $350 cost of defense, which would basically be $100 per case plus the $50 application fee. What I'll do, Mr. Cannon, is give you 90 days from the date of your release to either pay those court costs or set up a payment plan to pay those court costs. Otherwise, they'll go to judgment.
Yes, sir.
And if I didn't, I think I said this already, but revoke and terminate his supervision in the 2 VOP cases. As I previously stated, this appears to be a downward departure where you scored 20.7 months. And you're not going to prison due to the fact that you have an uncoerced plea bargain with the state. Do you understand that?
Yes, sir.
Okay. That's 9 months county jail. All right. I will need your fingerprints, Mr. Cannon, and then you have 30 days to appeal the judgment and sentence. All right, thank you.
Your Honor, this is Mr. Donald Hainish. He's in pretty much a similar boat with Mr. Brown.
Mr. Hanish, up here, please.
If we can leave Mr. Hainish on for plea or continue on September 2nd, we are hoping to bring this in for a resolution on that date.
So if it's not a resolution?
It'll be continued one cycle.
All right, so plea or continuance. All right, Mr. Hanish, we'll see you back on September 2nd, which is next Tuesday at 9 a.m.
Yep.
Okay.
I'll mail you one. Your Honor, this is Mr. Giovanni Hernandez in 25 CF 584. The situation with Mr. Hernandez is he actually has a violation of probation in Escambia County. I have attempted to reach out to Escambia County to confirm. The jail's website right now does not reflect there's a hold on Mr. Hernandez. If I can get confirmation that there's a hold on him before next Tuesday, the intent would be to ask the court and the state, I believe, would be on board with this, a stipulated motion to reduce these bonds to signature bonds so he can be transported to Escambia to deal with that violation while this case is proceeding. We haven't taken any depositions in the case to date. But I have to get confirmation that if there's a reduction in bond, he's going to be transported as opposed to just, here's the front door. Correct. So if we can leave him on for Tuesday, the 2nd, plea or continue, I'll reach out to the jail, and I have a feeling there's a hold because the department's own website says that supervision is an active suspension. So I think there's a hold at the jail, it just is not showing on their website. So once we get confirmation of that, maybe by later today, I would hopefully come into court tomorrow with a stipulated order reducing bond. We just need to get confirmation that there's a hold.
There appears to be a VOP warrant that was signed on March 24th.
Simon,
so there should be a hold. You're just trying to figure out if it's actually
correct
in place or not.
I even looked in the FDLE website. They have a database of active warrants, and he does not show up as having an active warrant. So
I found that one's not always accurate.
I don't necessarily. It's just another. It's glorified hearsay. I was looking all over the place to try to find if I could get this confirmation.
All right, so we'll see Mr. Hernandez back next week on Tuesday, September 2nd at 9 o'clock to determine whether or not he's got that hold.
So I can figure it out today. Okay. Your Honor, this is Kenneth Jones in 25 CF 1202. We have reached an agreement to resolve this case. At this time, Mr. Jones is going to be entering a no contest plea as charged. The agreed upon disposition is that he will be sentenced to time served, concurrent between the 2 counts. He would be assessed $615 in court costs, $150 in public defender fees, and he has previously been adjudicated. May I approach?
Yes, sir. All right, Mr. Jones, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Kenneth Joe Jones, June 30th, 1999.
All right, Mr. Jones, you're here in 25 CF 1202, where you're currently charged with possession of a controlled substance, third-degree felony, punishable up to 5 years in state prison, as well as possession of drug paraphernalia, first-degree misdemeanor, punishable up to 1 year in county jail. Do you understand that?
Yes, sir.
All right, I've been given a plea and sentencing agreement that would have you plea as charged, with your sentence being time served. That would be concurrent, $615 court costs and $150 PD fee. You'd be adjudicated guilty. Is that your understanding of the agreement?
Yes, sir.
Is that the state's agreement?
It is, Your Honor.
All right. Have you gone over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir.
Are you satisfied with your lawyer's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressure, or threatened you in order to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
Do you understand by entering a plea there won't be a trial of any kind, and you're giving up your trial rights, which are on page 1 and 2 of the agreement that you signed? And do you understand that you're waiving any potential defenses that you have? And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right. And what is your plea to the possession of controlled substance and the possession of drug paraphernalia?
No contest.
All right, I'm going to accept your no contest plea as freely, voluntarily, knowingly given. Adjudicates you guilty on both counts. Time served, $615 in court costs, $150 PD fee. Mr. Jones, I'll give you 90 days to set up a payment plan or pay those costs off. Otherwise, it will be a judgment against you. This is a guideline sentence. I've reviewed the guidelines that show 21 points, which is not a presumptive DOC sentence. I'll need you to be fingerprinted, Mr. Jones, and then you have 30 days to appeal the judgment and sentence of the court. All right, thank you, sir.
Your Honor, may we approach briefly on Mr. King?
Sure.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire. Take one. Have you been injured in an accident and need righteous representation? Call us. Because we fight fire. Damn thing ain't working. Whoa!
Not cool, bro. I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
Mr. King, we're going to put your case on October 29th, but if there becomes a resolution faster than that, you can come to an earlier date.
Your Honor, this is Ms. Lamb. She is in the middle of being evaluated for mitigation purposes, and we actually have some depositions scheduled to take place next week. We would be asking the court for a one-cycle continuance for Ms. Lamb.
Your Honor, that is without objection. Those depositions have been set.
Are those fact witness depositions, or it has something to do with mitigation?
They're fact witness.
Okay.
Yes.
All right. October 29th at 9 o'clock. I know it sounds like you're getting towards a resolution potentially, Mr. Kleins, but this case is over a year old as well.
Oh, there's a string of cases that are near the top of my list.
Yeah, I
So-
understand. I know they're all new to you, but you know,
Correct.
they've been pending for over a year.
Yes, sir.
All right, we'll see you back on October 29th, Ms. Lamb.
Your Honor, this is Mr. Aaron Knopfsinger. He is in the middle of the mitigation evaluation process. I know for a fact that he has already met with the doctor at least one time. I personally witnessed him at the jail with her. I would ask the court for a one-cycle continuance. So the court is aware, and I've talked with Ms. Basso about this. My intent is while this evaluation process plays out, we are going to be covering all the depositions. If there's any motion practice, we'll get into that as fast as we can. Ideally, I know the mitigation process sometimes can take a minute. Once that's done, my goal would be to have everything ready to go if there's no resolution here by agreement. But that's the situation. We are asking the court for a one-cycle continuance. I don't want to just kick this down to late December, but we're doing what we can here.
The state has no objection. We can get those depots set pretty quick because there's limited witnesses that need to be deposed. Most everything has been documented. Otherwise, the state would be ready.
Okay. All right, it'll be October 29th at 9 o'clock. And obviously, this case is even older than the last one.
Yes,
I know you're working on it, Mr. Kleins. You've only had it for a couple of months, but I want to make sure we're getting to a resolution.
Yes, sir.
All right, thank you. Can you all approach for a second? You can go, Mr. Knopfsinger. I'm just...
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Your Honor, this is Mr. Paris. If we can leave him on for plea or continue on September 2nd, we are hopefully really close to a resolution here.
State.
I have 1 second, Your Honor. I just want to. Want to make sure before. Sorry, Your Honor, I just want to, there's two theft cases, one of which the victim in the case positively said that the defendant did not do it. It was a different individual. And I just want to make sure I don't dismiss the incorrect case.
Okay. The work is still coming back on Tuesday.
We are, but...
Yes, Your Honor. I just want to,
Is that the reason why we're coming back Tuesday, not doing it today? I'm just trying to make sure I understand what you're saying, Mr.
no, that's not. If I may, because I'm really, what I've got in here is different. So we'll be dismissing one on Tuesday, Your Honor, but we should be able to still come in for a landing, hopefully, as well.
All right, Mr. Paris, we'll see you back on September 2nd. That's next Tuesday at 9 o'clock.
Thank you, Your Honor.
Thank you.
Get that, please. sign that. Go ahead and sign it, David. Today's the 27th. Your Honor, this is Mr. Christopher Porter. He is executing a plea agreement right now to resolve this. At this time, Mr. Porter is going to be, it's 8/27/25, going to be entering a no contest plea as charged to these 3 counts. The agreed upon disposition, a little funky, but counts 1 and 2, count 1 is a third-degree felony, count 2 is a first-degree misdemeanor. On those counts, Mr. Porter would be sentenced to 120 days in the county jail with credit for all time served. Count 3 is a second-degree misdemeanor. On that count, he will be sentenced to just time served. He would be assessed $615 in court costs, $150 for the cost of defense, and he has previously been adjudicated. May I approach?
Yes, sir. All right. Can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. Can you state your full name and date of birth, please?
Christopher Lee Porter, 10/26/1994.
All right, Mr. Porter, you're here in 25 CF 957, where you're charged with burglary of a structure, third-degree felony, punishment up to 5 years in state prison, possession of drug paraphernalia, first-degree misdemeanor, petty theft, second-degree misdemeanor. You understand that?
Yes, Your Honor.
Okay, and I've been handed a plea in the sentencing agreement that would have you plea as charged to 120 days county jail, credit for time served on counts 1 and 2, simply time served on petty theft, count 3, $615 court costs, and $150 cost of defense. Is that what you want to do today?
Yes, sir.
Did you go over this plea agreement with your lawyer?
I did.
Did you understand and sign it?
I do.
Are you satisfied with your attorney's advice and representation?
I am.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, Your Honor.
Are you currently suffering from any mental health issues?
I am not.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
They have not.
Has anyone promised you anything in return for your plea?
No, they have not.
You understand by entering a plea, there won't be a trial of any kind, and you're giving up your trial rights, which are on page 1 and 2 of that agreement that you've already signed.
Yes, I do.
And you understand that you're waiving all potential defenses that you may have.
Yes, I do.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes.
All right. And you understand you'll be adjudicated guilty, so that's a felony conviction on the burglary?
Yes.
All right. And what is your plea to the burglary, paraphernalia, and theft?
No contest.
All right, I'll accept your no contest plea as freely, voluntarily, knowingly given. Adjudicate you guilty on all counts. On counts 1 and 2, 120 days county jail with credit for time served. On count 3, it's time served. $615 court costs, $150 cost of defense. Mr. Porter, I'll give you 90 days from the date of your release to either pay or set up a payment plan for those court costs. Otherwise, it'll be a civil judgment against you. This is a guideline sentence. He scored 34.2 points. All right, Mr. Porter, I'll need you to be fingerprinted, and you have 30 days to appeal. Thank you. Oh, yeah, all jails concurrent.
Yes, thank you. Your Honor, this is Mr. Sledge approaching the podium in 24 CF 2745. We did recently receive the discovery in Mr. Sledge's case. He is in the evaluation process for competency. And I know Mr. Sledge would like to address the court. And I have advised him not to mention the facts of the case.
Crazy? I ain't crazy. Could you clarify something for the record for me, please? I'm charged with attempt to what? I mean, you saying it's not, can you clarify for the record?
I think we've talked about this numerous times in the past,
No.
Mr. Sledge.
No, I'm trying.
I'll certainly clear it up for you the
Okay.
best I can.
Right.
No, I think it's a second amended information from January 14th. Is that?
Attempted.
That's correct. Your Honor, I reviewed yesterday at the jail, I showed Mr. Sledge both the original amended information and the second amended information. So there were 2 amended informations filed in January. I think the first was filed on January 5th, I believe, and the second was filed.
The 8th and the 14th.
The reason, Your Honor, it was a typo.
I understand. I know
I'm
we've
just-
discussed this before. I just want to make sure I look at it. Because I don't want to really address this every time, Mr. Sledge.
No, you haven't addressed it. I'm just trying to figure out, it's a attempt.
We've talked about this numerous times,
Can you
Mr. Sledge.
identify?
Do you want me to clarify it or not?
Yeah,
Okay.
please do.
What you're currently charged with, as of the second amended information filed on January 14th, 2025, is count 1, attempted first-degree premeditated murder with a firearm, count 2, tampering with evidence, count 3, false imprisonment, count 4, aggravated battery causing great bodily harm by possessing and discharging a firearm. That's a 1020 life case. And count 5 is possession of a firearm by a convicted felon, also 1020 life.
Can you read the statute for that case?
Which one?
That attempt, because it say without executing right there. It said without executing to homicide, and the paper I'm looking at. It don't say attempt to murder or premeditated. It say without executing. It ain't no charge of without.
Okay, but what you have to understand is that the statute 777.04 is the attempt statute.
That's called murder. Pull it up. I can pull it up for you. It say one word, murder. That's not no attempt.
That's 78204.
I'm on law.
Mr. Sledge, I'm not going to do this with you again.
I want you to clarify it for the record.
I just did.
Okay. But you could have clarified the statute. You can read it out for the record. That's all.
You're charged with attempted first-degree premeditated murder with a firearm. Can I finish? 782.041 is the murder statute. 777.04 is the attempt statute. They're both listed.
Well, read it for me. I can tell you what it says. Read it.
Why do you need me to read something that you've already read?
For the record, so if it's an appeal, it can be.
It's filed in the court file, so it's part of the record.
But it's protocol. If I ask you to justify something in court, you're supposed to justify it for the record. Am I right or wrong?
You're wrong.
Well, can I have the indictment for this premeditated attempt? Because it's a capital offense. You got to have the indictment. Can you give it to me, please?
It's actually a first-degree felony, level 9.
Well, it's punishable by life, and it requires an indictment. And can I have it? I mean, you got everything else figured out. Can you give me this indictment paper information file, please?
Can everyone agree, looking at the information, this is listed as a F1, which is a first-degree felony?
I explained to Mr. Sledge yesterday that this does not require an indictment.
Premeditated does require an indictment.
Attempted does not.
All right. I don't know what school you went to. Twin Hills Park ain't gonna cut it. You said if it was suppressing hearing, we're gonna find out then. How about that?
Mr. Kleins, what would you like to do with the case?
I would like to continue this one cycle.
Well, you gonna ask for the
because of the evaluation that's being done?
I don't want no evaluation.
Well,
you can't evaluate me. I just told you I decline. I decline. It's against the law to force me to do something I don't want to do. I decline. I'm in my right stage. I done been to prison 7 times. I'm ready for this motion to suppress hearing. Let's get on that and get the trial. Let's stop holding me up.
October 29th, 9 o'clock for your next pretrial.
Yeah, you gonna let me go.
Say again?
You going to jail.
I'm going to jail?
Yeah, I bet you. On my mama, you gonna go. Okay. You better have this indictment and that filing information and that warrant that you said I killed somebody, and I did on December 1st. Anything
all right, thank you, Mr. Sledge. That's all.
False information.
Your Honor, this is Mr. Billy Thorne. Over here, Bill. 25 CF 1059. Mr. Thorne has agreed with the state and signed a written plea agreement to resolve this case. At this time, Mr. Thorne would be entering a no contest plea as charged. The agreed upon disposition, this is a downward departure, would be 90 days in the Okaloosa County Jail with credit for all time served. He would be assessed $967 in court costs, $150 for the cost of the defense, and he has previously been adjudicated. May I approach?
Yes, sir. No worries. I'm sorry, you said the downward departure was uncoerced plea bargain?
Yes, Your Honor.
All right. Mr. Thorne, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your full name and date of birth, please? Can you state your full name and date of birth, please?
8/12/56, 1956.
What's your full name?
Billy Douglas Thorne.
Okay, Mr. Thorne, you're here in 25 CF 1059, charged with one count of battery on a detainee, which is a third-degree felony, punishable up to 5 years in state prison. Do you understand that?
Sir.
I've been given a plea and sentencing agreement that would have you plea as charged to an adjudication of guilt, which is a felony conviction. You'd have 90 days county jail, credit for all time served. I believe he had another case. Is he still serving that one?
No.
That case, I believe the sentence ended in June.
Okay, I just wanted to make sure
Yeah,
for concurrent consecutive purposes.
Yes, sir. I knew he pled earlier in the year.
Okay. So it'll be 90 days county jail with credit for time served on this case, $967 in court costs, and $150 cost of defense. Is that what you want to do today, Mr. Thorne?
Yes, sir.
Did you go over this form with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir.
Are you satisfied with your attorney's advice and representation?
Oh, yeah.
Are,
Yes, sir.
are you currently under the influence of any alcohol, drugs, or controlled substances? No? Okay.
No,
Are you
sir.
currently suffering from any mental health issues?
No, sir.
All right.
I'm just sick right now.
You're
Well,
physically
cold.
sick?
I'm sick.
Okay. Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for this plea?
No, sir.
You understand by entering a plea, there won't be a trial of any kind, and you're giving up your trial rights, which are on page 1 and 2 of the agreement that you signed.
Yes, sir.
Do you understand you're waiving any potential defenses that you may have?
Yes, sir.
Okay. And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
And what is your plea to the one count of battery on a detainee?
No contact.
All right, I'll accept your no contest plea as freely, voluntarily, knowingly given. Sentence you to 90 days county jail with credit for all time served, $967 in court costs, $150 cost of defense. Mr. Thorne, I'll give you 90 days from the date that you're released to either pay those court costs or set up a payment plan with the clerk's office. Otherwise, it'll be a civil judgment against you. You're adjudicated guilty, so I'm going to need your fingerprints, and you'll have 30 days to appeal the judgment and sentence of the court.
Hey, John, right?
And as previously announced, this is a downward departure based on the uncoerced plea bargain between you and the state, Mr. Thorne.
Sir.
It was an adjudication. I'm just, okay.
Your Honor, this is Calvin Tipton.
Go ahead.
I know Mr. Tipton is even older than Ms. Lamb and Mr. Knopfsinger. There were
Well,
some
his case is what you.
Yes.
Okay.
Yes. There were some discovery issues that we worked through recently. I have talked with Ms. Basso. There's about 2 or 3 more depositions that need to take place for Mr. Tipton. My goal is to have those ready and done by the October 29th date.
We did discuss it, Your Honor. Discovery was previously shared with Mr. Klein's predecessor. There were some issues. We filled in the gaps of what they were not able to find. Based on that, he does wish some additional depositions. We will make sure there's time available for him to get those done. I know they're important. He's been good about reaching out.
Okay. I think last time we talked about trial in September, so.
I know we did. And then discovery issues popped up.
Okay,
so.
I understand. All right, October 29th at 9 o'clock. Let's make this one a priority to get resolved next time around.
Yes, sir.
Sounds good,
All
Judge.
right, thank you.
All right, I'll come to the jail and talk to you. Juveniles? Okay, sweet. What's that? I don't know.
Yeah. All right, Ken, can you switch off?
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Before. He has come to my office and had his office appointment at that regularly scheduled time. You know, he's very interested in the outcome of his case. We would ask the court to consider this an oversight and ask if the court would recall the capias and reset this matter for 9/2.
They'd have a position.
No objection.
All right, Mr. Perdue, because you came in and acknowledged your mistake, I'm going to withdraw the capias, so you won't be taken into custody today, but you have to make sure to be on top of those court dates. Because you were here for your arraignment date on July 10th. We gave you Monday, August 25th at 1 o'clock is your court date. So just make sure that you're writing those things down and appear in time. Stay in touch with Ms. Rivers. What date are you asking for?
Your Honor, for Tuesday, September 2nd.
All right, so we'll see you next Tuesday, September 2nd.
Thank you, Your Honor.
Is there anything that we have to take that's urgent or before we take a little bit of a abbreviated lunch break?
Judge, I've just got two people that are set for today, but they bonded out of jail. And so I was, both of them are going to be, I'll move for continuance. The only one that I think you might question.
Let's just call him up real quick then, Mr. Williams.
Billy Allen. Judge, Mr. Allen's ambulatory with a cane. If we can have him just stay where he is.
Yeah, that's fine.
It's the first time up. and I'm going to move for a continuance.
All right. Did y'all get the depots done on July 30th?
We did.
Okay. Any more to go?
Judge, I don't think so, although I've been given information by one of the witnesses that there may be some telephone recordings, voicemail recordings from the alleged, or one of the alleged victims. I'll need to look at those and see those and determine if they're of value, and if so, I'll provide them to the state.
All right, Mr. Allen, we're going to put your next court date on October 27th, and that's going to be at 1 p.m.
Thank you,
Make
Judge.
sure you stay in touch with Mr. Williams. All right, we'll see you back that date, Mr. Allen.
Judge, the next one is Roger Bradshaw. Judge, Mr. Bradshaw is the third time up. He bonded out around 7/17. We last had contact with him on 7/31. We have deposed the alleged victim. I want him to come in and listen to that, and then discuss the offer and any potential counter offers. I say he's bonded out 7/17. He may have bonded out on the 15th.
I just like to point out, I think Mr. Bradshaw has filed at least one, or at least, I think several actually, kind of pro se handwritten motions. You understand, and I've done orders striking them because you're represented by a lawyer. If he wants to adopt them, he certainly can, but otherwise they're what we call a nullity. It's like they never got filed. So just communicate with your lawyer going forward, and if y'all want to file anything, he can handle that part.
I have discussed that with him, as well as his rights under Ferretta.
All right, so because you've been released, Mr. Bradshaw, we'll put you on October 27th, and that's going to be at 1 p.m. All right, we'll see you back on that date.
Thank you, Judge.
You have any other in custody, or out of custody?
I have one, Your Honor.
All right. Say again? All right.
And Your Honor, apparently I do as well. That would be Byron Williams, 25 CF 1131. He is present and approaching, Your Honor. We do have a hearing set for tomorrow at 9 a.m. We're asking otherwise for this to be continued to the October pretrial docket, but note that it is a hearing set for tomorrow at 9 a.m.
All right, Ms. Rivers, I see the notice of the hearing for tomorrow, but I didn't see the motion.
Your Honor, I had previously filed the motion quite a while back. I can provide the court with a copy.
Back far enough.
Your Honor, it had to do with seeking to be relieved as counsel based on the bond that
Here
was
it is.
posted.
June 19th.
Yes, Your Honor.
All right, Mr. Williams, and we're going to see you back for that hearing tomorrow at 2 o'clock. All right.
Sorry. Was it 2 o'clock?
That's what your notice says.
Yes, thank you, Your Honor.
Okay.
So sorry, I did misspeak.
All right, otherwise, October 27th at 1 o'clock for pretrial conference.
Thank you, Your Honor.
Judge, I stand corrected. Jeffrey Jenkins is here.
Jenkins?
Yes, sir. I'm trying to, it looks like he was on for pretrial on Monday. If we can call him, which would explain why I don't have his file with me. If we can go ahead and call him up, and he can explain to the court why he missed court, and hopefully the court will withdraw his capias.
Do you have a case number for him?
Judge, I do. I've got 4625 CF 000892.
I think we did add him to the updated docket.
I got it on my wallet.
Did we do anything with this case yesterday or Monday?
Judge, I don't have, well, actually, I may have my notes from Monday.
It's set for today, apparently.
Today.
Okay. Sorry, Judge, my computerized notes had it for the 25th.
All right,
In fact, looking at my notes, I'm showing not on this docket, is he on the jail one by mistake?
He was on the jail docket. I think the issue was he bonded out after this date was set.
Yes, sir.
All right. So what do you want to do with this case? It's the first time up.
Judge, I'm going to move to continue it.
October 29th, 9 o'clock, Mr. Jenkins. I'm sorry, October 27th at 1 o'clock.
Okay, Mr. Jenkins.
We'll see you back on that date.
All right, thank you very much.
Did y'all have anyone else that was out of custody?
Just one, Your Honor. It'll be a quick one, though.
All right.
Christian Rosario. Your Honor, Mr. Rosario is present and approaching. He's before the court in 25 CF 443. I believe the state has an announcement in this case.
The state is going to dismiss the case against Mr. Rosario per the victim's wishes.
All right. All right, Mr. Rosario, state's dismissed your case. You're free to go. Thank you.
All right, thank you, Your Honor. That's it.
All right. We're going to take about a 30-minute break for lunch.
Thank you.
Let's try to come back about 12.